Okay, we're gonna go ahead and get started until Chairman Leverett gets here. First bill committee will hear is House Bill 446, Vice Chairman Reeves.
May I present from here or should I?
That's fine. Go ahead.
Thank you so much, Mr. Chairman. I present to the committee House Bill 446, the drive-by shooting bill. This bill has been worked on more this year after a lot of work last year. I appreciate the review by Georgia Association of Criminal Defense Lawyers as well as Prosecuting Attorneys Council. The subcommittee heard from a former prosecutor from Gwinnett as well as public safety advocate, and has more information and statistics. And this will give more specificity to the law on drive-by shootings, keep our communities safer, give some more tools and specificity under the Georgia Code. So present the bill to you and respectfully request passage.
Okay. All right. Anybody signed up to speak to the bill? Trying to get the sign up sheet. All right, bear with me. House Bill 446, Robert Smith with PAC. Vice Chairman Reeves, is that the version that they have seen, or?
It is. The versions that are in your folder are ones that Georgia Association of Criminal Defense Lawyers, Prosecuting Attorneys Council worked on extensively since our last meeting. It's
Okay.
LC 550268S.
All right, sounds good. I had a motion and a second. All those in favor of the passage of House Bill 446, LC 550268. Yes. Say aye. All those opposed, no. Congratulations. You're on the full. All right. Then I think you've got another one, House Bill 656. Tell us about it.
Thank you, Mr. Chairman. This bill is a shorter bill than it was the last time this committee heard it. Representative Darlene Taylor, Chair Lady Darlene Taylor, and her police chief and sheriff asked me to look at this. We shrank this down to just dealing with child molesters who cross state lines into Georgia with plans to molest a child, but who were stopped short of laying hands on that child. Alabama and Florida, our fellow states in the 11th Circuit, have a law similar to this one that lets that specifically be a crime. This version LC 550271S was extensively reviewed since the last time this was heard by both prosecutors and criminal defense lawyers. I appreciate their work on it. And this bill will protect Georgia children just like children in Florida and Alabama are being protected similarly right now.
Okay. Questions from members of the committee to the author of the bill? I see none. Let's see, for 656, Robert Smith from PAC. Okay. I got a question from Representative Neal.
Thank you to the chair. Thank you to the author. I just had a clarification question. Does this correspond with any of the interstate, intrastate crime? Is there a necessity to merge that with that terminology we use for crossing lines on?
The police chief and sheriff in Thomas County and Thomasville, they looked at, there is some level of federal law out there, but this gives a state law that is more specific and stronger, and it's similar to what our adjacent states have down there in the southwest part of the state. So the federal law does not quite intercept people who cross state lines, but who are unsuccessful in their attempt to molest the child.
All right. Seeing no other questions. Gackel didn't want to speak to this. Okay, all right. Even to the changes? Okay, all right. Thank you. Okay. Seeing none, what's the will, of the yes. Vice Chairman
I
Ray.
appreciate, our committee council. There are, some clerical suggestions that,
This be needed in the form of an amendment.
yes, yes,
Okay.
Mr. Chairman, I
All
do have an amendment.
Let's get to that posture first.
Okay.
Motion do pass in second. All right, now would be time, Vice Chairman Reeves.
Thank you, Chairman. On line 11, strike without and put outside. So it would read, travels any distance into the state from outside the state instead of without the state. And then after the word state, between the word state and or, put a comma. So reads this state, comma, or causes another person to do so. And then on line 12, comma, for the purpose of contacting any child. So it adds 2 commas and substitutes outside for without.
I mean, I kind of enjoyed the without. I mean, that's pretty clear to me, Vice Chairman Reeves. I'm
That's
just
kinda-
saying.
That's kind of like in squatters, the sheriff will turn out the squatter. So,
Okay,
yeah.
all right, well, just.
I mean, we're dealing with Alabama and North Florida, so,
Better be a
uh,
Georgia judge interpreting it, and we think.
we'll be explicit. We'll be explicit.
Or is it your contention that judge wouldn't understand what without says?
These are Georgia judges, but we want to send a word to those child molesters in Alabama and Florida. We want to
Okay,
be clear.
all right. Gentleman was very careful with that response, and I appreciate it. Number 6, Representative Neal.
Yes, thank you. And to the point of that clarification, that's why I was asking about the terms that we currently use, and I'm trying to find it, of interstate or intrastate to clarify. So if instead of saying outside, like there's a way that we already say that. So I was just asking.
All right, just making sure that I recognize one of our jurists with us, Judge Lawton Stevens from the Western Circuit. Thank you so much for being with us, Your Honor. Yes, sir. Thank you for what you do for us, and thanks for indulging our little fun without or outside there. Okay. What's the will of the committee on the Reeves Amendment?
Motion's passed.
All right, got a motion to pass. Got a second. All those in favor of the Reeves Amendment say aye. All those opposed, same sign. All right, the Reeves Amendment is on. I'll call the question. And after I call the question and we vote, I'm going to let Chairman Leverett take back over his subcommittee, as much as I do enjoy subcommittee work as a chair of one. All those in favor of the passage of the bill with the Reeves Amendment say aye. All those opposed, same sign. Congratulations. I'm going to yield to Chairman Leverett.
All right, ladies and gentlemen, sorry to was late to join you here today. I'm going to go a little bit out of order here because I think we have some witnesses on House Bill 1383 that may need to leave. So I'm going to go ahead and call Representative Reeves here to tell us about your bill. See which mic we got. There we go.
Thank you, Chairman. I will be very brief and give time for our members of federal law enforcement. I believe there's a letter in your packet from Department of Homeland Security. We have some of the officials here. I present to you House Bill 1383. This bill was requested by federal authorities because when the citizens arrest law was repealed a few years ago, that was the main basis for federal jurisdiction to arrest on things other than a federal crime. Georgia is one of 2 states that does not have a specific state basis for a federal arrest dealing with federal crimes. This is a very narrowly tailored bill that allows federal law enforcement to make an arrest in Georgia, even if it's not a federal offense, as long as there is cooperation with the state authorities. And the two examples they gave are incidental events. That's like if there's a state patrol crash and they are overwhelmed, they can request in federal authorities to assist in that situation. The second is an expected event. That is one example is a human trafficking raid where there are some offenses that may or may not be federal offenses, but there certainly would be benefits of having federal law enforcement there. Georgia State Patrol, Police Chiefs Association, and Sheriffs, or Georgia State Patrol and Police Chiefs Association are comfortable with the bill. The sheriffs are neutral. And this is something that Vice Chairman Houston Gaines, as well as our chairman of the full committee, reviewed. And I'm proud to request this bill and turn it over to federal law enforcement to expand further on the need and the scope of the bill.
Afternoon, ladies and gentlemen. My name is Dave Jelinas.
We need you on the mic. So if you'll swap seats with, yes, sir, if you would. We have we especially have, I think, a at-home viewing audience today, but normally we do have media services. And so if you're not on the mic, they can't really.
There are dozens of folks.
Dozens. Afternoon, ladies and gentlemen. My name is Dave Jelinas. I'm a special agent with Homeland Security Investigations. I'm also a gang investigator for Atlanta. So the power of federal law enforcement agent or an officer is expressly granted pursuant to federal statute. As a general rule, these statutes expressly authorize federal law enforcement to make arrests for only federal laws. HSI, in particular, does not have any federal authority to make arrests for state crimes. As Representative Reeves mentioned, we are the only state in the Southeast that currently does not give federal law enforcement any sort of ability or authority to make arrests for state crimes. As a gang investigator, this is quite a hurdle for us. It affects our partnership with state and locals. It affects our ability to act in the field, and it puts us behind the curve. That's it.
Thank you. You got a question? Does that come from Representative Neal? Is that you? Representative Neal.
Thank you to the chair. Thank you for your testimony. So I guess my first question is, what problems are you having with arrest, or what issues are you facing? Are people not responding when you contact an agency?
So, well, the issue for us as a gang investigator, for me, is we want to work with state and locals. Like yesterday, I was out with APD gang unit, helping them. And currently, our only capability in the field for state crimes is to do surveillance. So I'll give you an example. If we are out with APD working a gang suppression operation and they encounter individuals and they all take off running, we can't do anything. We have no authority to help them in a foot pursuit or detaining individuals. So we are pretty much, at that point in time, we're worthless to our state and locals. We're out there to do surveillance. We can do surveillance, but anything other than that, we have very specific rules that we have to follow in order for us to act for a state level offense.
Is that the same for like joint partnerships? Like, for instance, when I worked undercover and we had like a joint partnership with like FBI, ATF, and all those people, for everybody was helping, like they can be hands-on. So I guess I'm trying to understand. So where's the divide?
So the changes was a couple of years ago.
Okay.
When Georgia repealed Citizens Arrest Authority.
Okay. So you're saying this is within the last recent years?
Yes, ma'am.
Okay.
Yes, ma'am.
Gotcha. Now it makes sense. Thank you.
I have some examples of where that actually came in. Okay, yes. Okay. Yes, ma'am. To directly answer your question, let me identify myself. My name's Robert Taylor. I'm a special agent with Homeland Security Investigations, and I also work in the gang and national security group. A couple of examples that I've actually been through. So I work pretty extensively with state and local partners. Less than a year ago, I was working a crime suppression detail. There was a pursuit, ended up a guy bailed out of his car and a fight ensued. And under this current act, I basically was hamstrung with making the decision of, do I put myself in jeopardy or do I interfere or intervene and assist the lawyers, the police officers. The suspect was, giving them everything that they wanted. And so again, it is affecting us being able to intervene in that situation and assist our state and local counterparts. And I come from a state and local background. I policed locally for a bunch of years. And I know that for us, if we're in that situation, being able to have somebody that can come help, we definitely want them there. And the minute we don't, then we're not really going to be invited back. Same situation, doing a crime suppression detail, GSPs, chasing guy about 100 miles an hour down the wrong side of the road. Again, we're just hamstrung. We can't intervene. We can't assist. The guy bailed out, and we're basically hamstrung with being able to provide any assistance that's fruitful to capturing or assisting in any way.
Any follow-up,
There you go.
Representative Neal? Okay.
He's got,
Orderly Hong. Did you want to ask?
I don't know. Are you doing a statement?
Just
I can
one
wait.
last-
Okay.
Yes, ma'am. So again, I'm with Homeland Security Investigations, and I'm currently on our human trafficking task force. And just understand that while we've heard examples of non-compliant suspects, this also has to do with compliant subjects. We often work undercover investigations, working prostitution operations. And of course, prostitution, pandering, these are state misdemeanors. Simply myself handcuffing a subject that's compliant and transporting them to an interview room or transporting them to a police car. I can't do that anymore because I can't put hands on them. And this is really more for just restraining a subject or detaining them. This isn't for sole arrest powers. So again, we talk about non-compliant all the way to just compliant. We are completely restricted. And just as my colleagues mentioned, when we do these operations all the time, so many of our crimes initiate at the local level. And then we have to determine if a federal crime is there, but we have to interview them. But again, we need to be there more than just a surveillance role, but we can't right now.
Floor Leader Hong.
Thank you, Chairman. So just so I understand, currently you are stating that because you do not have that arrest power, are you having to wait for law enforcement of that jurisdiction to come and assist if they're not there? Or
And it's not even really just arrest, it's just detention authority, because we're not looking to arrest and process someone through the local courts. It's simply just detaining someone. Again, compliant or non-compliant. I believe in the notes there, we give an incidental or an expected example. The expected example is we're out on an op, it's pre-planned. The officers are there, but we have to be only on an intelligence role or a surveillance role. We can't simply assist on a takedown, assist at their chase, assist transporting from someone to an interview room. But yes, it's when there's a local law enforcement officer there.
so it is, if I may, another question. So we're restricting certain things in certain circumstances. Is that what you're stating?
Our whole goal is to assist local law enforcement, and we kind of have to stand back and watch.
Okay, thank you.
Thank you, Representative Neal.
Thank you. So I support the overall concept of the bill, but I do have a few questions. So some of my friends that didn't go through Georgia Post and learn Georgia laws, if I were to ask them about something when it comes to Georgia laws and they work for a federal agency, they don't know.
Mhm.
So I guess my question is, by doing something like that, do the federal entities actually know our Georgia laws? Outside the traditional, hey, if you shoot somebody, of course, that's murder. Outside of those things, do they know the Georgia laws to be able to effectively utilize this, or would they still need to call in local authorities to handle?
She's the attorney.
Okay. I guess maybe clarify your training.
That's fine. Usually I'm loud enough, but this is fine. And my name is Bruna Walls. I am currently appointed counsel for Homeland Security Investigations, and I do have to give the disclaimer because I'm an attorney, so I do not make statements on behalf of ICE or Homeland Security Investigations. This is something that we associated with federal law enforcement are in our private citizens position are pushing for. But obviously, this is the reason why the special agents are here, is because this impacts how they're able to provide support for local law enforcement. But if you want to restate your question, I would be more than happy to answer.
Yes, thank you. So I was giving examples such as I have federal authorities that are friends of mine that they never, some came through Georgia Post, so you would know Georgia laws to be able to arrest for them. But if you have instances where you have federal entities coming into the state and they don't know Georgia laws, but we've given them the power to arrest for them, absent of Georgia law enforcement, absent of the obvious crimes such as murder, the things that you would obviously see, how do we know that they, know our laws well enough to be effective and not become more of a liability?
Absolutely. And if you look at the statute, I know the position starts on the last draft I have was on line 59. So the purpose of the bill is not to create an independent power for federal law enforcement. Okay. So the state of Georgia, and me being a citizen of the state of Georgia, and I understand that we want to maintain that separation of powers and not give federal agents and federal law enforcement the ability to just run amok in the state of Georgia. So the purpose of the bill is not to act independently and not to go out and be on your government vehicle and just start arresting people on Georgia statute, which you are correct in stating that they do not receive training for independent state statutes, right? So that's the first answer. The second portion of it is it's very specific on the statute that indicates that federal law enforcement will only act at the request of assistance and aid of a state and local law enforcement.
And what line is that on?
That is it starts on line 59, and it's that sentence.
61.
I'm sorry, 61. So it starts on 59. It says, upon request of a law enforcement officer of this state or of any of this county, municipality, or political subdivision. And the purpose is for aiding and assisting state and local law enforcement. By no shape or form do we have an expectation that federal law enforcement is going to know what Georgia law is.
Okay.
We are relying 100% on state and local law enforcement to tell us, hey, this is a crime and we want to detain and we want to arrest that person. But federal law enforcement is going to make that inquiry of state and local law enforcement and will not act independently.
Gotcha.
That's what the purpose of the statute is, and that's why it's written that way.
Understood. Thank you so much.
Of course.
Thank you, Representative Neal. Floor leader Hong.
Thank you, Chairman. Just one clarification. I know we kept talking about detain. In the previous testimony had stated that this will only allow for it to be detained, right? To have detaining powers, correct?
Yes, ma'am.
Okay. Representative Reeves, can we see what the LC number is? Because I think the copy that we have, and is there a sub that we may not know about?
Line 59 says may detain a person upon request of law enforcement.
And is that LC number LC 394247?
It is the
Okay.
originally filed bill that's on the internet.
Okay.
And in line number 16, as far as law enforcement officer of any county, that, and it looks like that language was added. It's your intention to say may arrest?
That's of this state.
Correct.
Right.
I understand. Okay. Thank you.
Right. That's current. These are current state officials, and line 59 and following pertains to the detaining by federal officials upon request.
Thank you.
Representative Neal.
Yes, thank you to the chair. So question, I guess, for the author. So would it be problematic on line 59 if it says may? Does may still open it up to the ability for a federal official to arrest instead of detain?
No, because this is plugging the hole in the jurisdictional landscape that was created by the repeal of the citizens arrest law. This gives authorization for detaining by federal law enforcement upon request of state authorities.
Okay.
So I have a question, Representative, if you want to play the musical chairs again and jump. Well, you could stay where you're seated, ma'am. I think, is there another chair there for you? Or you can scoot up to that? We do have, I'm just trying to utilize our neat 2 microphone system we have here.
All right.
So I gather then the main function of the bill is to authorize federal law enforcement to exercise the ability to detain and to lay hands upon people when they are conducting an operation in conjunction with state officials.
That's right.
And the state officials request that they take certain action.
That's right.
Is that a fair statement? Oh, sorry, I didn't have you on, excuse me. So that's a correct statement.
That's right.
And so, and my understanding is this is not to authorize federal officials to conduct their own operations solely without the cooperation or request of state officials.
That's right.
Is that correct? Okay. And so right now, because we don't have the citizen arrest law, we're not undoing that repeal here. This is just a limited conferral of authority on federal officials.
That's right.
If you're assisting and someone gets loose and flees, you just have to wave goodbye.
Current,
Can't
under
really do
current
anything.
law.
Currently.
That's right.
In this, you would be able to assist in detaining. Now, it says detain. Does that mean you could actually go lay hands upon someone and stop them and then take them back, or is it more limited with that language?
May I?
Absolutely.
I'm looking at you.
Okay,
Sorry.
I just want to make sure.
Yeah.
I'm going to give you the general term because detention is very different in every state. So that's that portion of it. The state of Georgia is very fluid in what detention is considered. So are we talking about handcuffs, or are we talking about I'm going to hold this guy back and put ties on him until I have state and local law enforcement then actually arrest for, let's say, assaulting a police officer? So yes, our understanding is the detention is a language that's appropriate because that's the appropriate that's used in Georgia case law as well as statute.
Okay. So the sort of conceptual we're talking about is a state law enforcement officer says, please transport this guy somewhere, or please take this guy and put him in the car, or whatever it is. But right now, technically, you're subject to liability if you touch somebody because you don't have arrest powers or detention power.
That's correct.
Okay. And we're trying to plug that hole here. Correct. Okay. And I'm jumping back to the author, but it looks like the first page, we're just doing sort of some cleanup in 17-420.
That's right.
Okay. That's unrelated to the primary function of the bill to confer.
That's right. In the course of circulating this with law enforcement, those tweaks were made, but that basically clarifies what's currently going on in Georgia.
Okay.
No substantial change.
Okay. All right. You got
And I will note, there was a question about a sub. I will acknowledge pardons and paroles. They have some questions on language. We're working with them on that, but this is going forward. Okay, yeah,
We would prefer peace officers stay in.
sure.
uh,
And I've been asked to,
different things.
I've been asked to proceed with the current language. We're working with them on input from
Okay.
them.
All right. Thank you. Representative Neal?
Yes, I had a question about detention versus arrest in when it comes to transporting. And maybe Pat can advise. Is there an arrest issue? He's making a face. Can you talk to us about how this pertains to detention versus arrest? And if federal authorities are transporting someone that's supposed to be detained, help me there.
If I may just interject. So it's very unlikely that a federal authority will be transporting for local law enforcement, because if someone is being detained or arrested for a state charge, really we're detaining them until transport is conducted by state and local law enforcement to state and local law enforcement jails. So it's the only, generally speaking, and that's obviously there are caveats to that, but generally speaking, we won't be doing a physical transport to somebody to a state and local jail unless there's there's got to be exceptions to that, but yes.
So one of the examples is if, say, for example, we're working an undercover operation with a local sheriff's office and maybe a girl is arrested for prostitution. However, we as federal agents suspect that she's actually a victim of sex trafficking. I might want to transport her from the hotel to maybe a local NGO so she can have a sexual assault examination, so we can interview her, so we can determine if there's a larger federal crime. But I can't transport her because technically she's only under custody for a state crime. So that's where I want to continue doing my job and investigate if there's a larger crime at hand, but I can't right now. So that would be times when we might transport someone.
Okay, and then I had a follow-up to Chair.
But let me, if I can just seek one clarification on that comment. So again, to your point, you can't do that currently under the state of law. This would allow you to make that transport.
Yes, sir.
Okay. All right. Thank you. I'm sorry, Representative.
Oh, no, no problem. I did want to go back to line 59 and I just was considering a friendly amendment if may should be shall only to prevent us having the issue where an independent arrest does happen. Line 59, changing may to shall only.
Representative Neal, with the additional language in line 60 to 65, I think the current version, if a court were to review that would make it clear the limitations of the authority. And also what this bill attempted to do was just codify and give a jurisdictional basis for the longstanding cooperation between federal and state authorities that occurred before citizens' arrest was repealed. And I think lines 59 through 65 and the rest of the bill gives an ample, clarification of the limits of that authority.
All right, Representative Reeves, I'm sorry, I didn't have your mic on, but I think you were just saying you'd rather not make that amendment because you think the language as it is sufficient.
Correct. The federal authorities drafted it or had input on 59 through 65, giving limitations on that based on the longstanding work between federal and state authorities, and the other lines they believe give ample interpretation of that.
Representative Neal?
And also anytime you have shall, that almost gives a requirement or mandate or positive, you shall do it. Whereas may do it upon request of local law enforcement. That's more of the posture of the federal authorities with state authorities.
Okay, I was just thinking about lawsuits where if a judge had to make a decision or if an arrest is made independently and a judge had to give their discretion, well, and the battle would be like, well, it says they may.
They may do it upon request of a law enforcement officer and then 6 more lines. So that gives a limited circumstance where it's authorized.
Okay, thank you.
Thank you, Representative Neal.
Yes.
All right. Did you have another?
No.
We were just trying to get the light shut off. Okay. All right. Does any members of the committee have any other questions of these witnesses? This was a 5-for-1. It was great. All right. Is there anyone else here? Did you wish to say anything, Representative Reeves, before I move along? No. Okay.
No, Mr.
Do we have any other witnesses here to testify on 1383? All right. All right. We got to do musical chairs again, ladies and gentlemen. I'm sorry. Thank you for your testimony.
May I be excused?
You certainly may. Thank you for your service to our country too. All right, which microphone would you prefer, Ms. Smith?
Poor lonely state prosecutor gets up here surrounded by the feds. Robert Smith, Prosecuting Attorney's Counsel, and I'm going to try to answer a question. The other thing I'm going to tell you about is that the case you're thinking about is Williams versus the state, 171 Georgia Appeals 807. It's a 1984 decision. DEA officer made a misdemeanor arrest, I believe, in Hartsfield, Jackson Airport. Our Court of Appeals said that because the way our law is structured, federal officers don't have the power of arrest in the state of Georgia. We've worked with our federal partners. I can't say with certainty about these agencies, but I know that I've used the marshals before to help me obtain fugitives when we had warrants out. They do a very fine job of that, grabbing, transporting, and taking. What this bill does is it allows, when a request is made, basically you get a warrant, and then either you have a warrant or you don't have a warrant. But if a law enforcement officer, and I know I've got 2 former law enforcement officers on this panel, if you were to pick up the phone and call, if this is passed, you could pick up the phone and say, hey, I need you to go get person X. Call the FBI, ATF, DEA, any of the alphabet. They would then be authorized under this bill to go grab and detain, with or without the fact that you have a warrant. You don't have to have a warrant. This basically gives them that arrest authority. So that's, and it's chained to you. That's the thing that part of my confusion is the original. I heard that they wanted to have the feds, the federal agent officers wanted to be able to make independent arrests from Georgia officers. And I'm not sure that's what this bill does. I think this bill goes a half step. The concern also, and I don't want to speak, and it's one of the things I always get very grumpy about, is when somebody speaks out of turn on my behalf. I speak about because I'm a prosecutor and and a government lawyer. I don't want to speak from a former employee, my former client with the parole board, but I believe I can say that one of their concerns is that we don't use law enforcement officer and peace officer interchangeably. Those are 2 different concepts. A law enforcement officer is much more broader than I think I'm going to get it backwards. I think peace officers versus law enforcement officers, one of them includes jailers, one doesn't, because jailers do not have arrest authority. And that's one thing I'm also going to remind you about, that under our Georgia Supreme Court, people like campus police officers and municipal officers do not have authority to go beyond their borders to exercise law. A sheriff's deputy can't call up a University of Georgia police officer and say, hey, go arrest somebody or go detain somebody. Because the UGA police power ends at the campus. So that's just some of the comparisons, and let you know what this bill does and doesn't do. Representative O'Neill, I think you had a question about transport.
Yeah.
And I know that I've used the marshals before, and I think that in this, and that basically if you call up and say, hey, go get someone, what is detention? That's something we're gonna have to argue about in court.
Yeah. And I think that's what I was trying to avoid, but I got you.
Yeah. And I'll stand for any other questions.
Thank you. Well, Representative Neal's light is.
No,
blinking.
sorry, had a thought. So like, that's the point. So if somebody's detained and then you put them in a car and most law enforcement back doors are locked, when you shut it, does that convert?
That's we actually talk about that for 3 or 4 weeks in law school as to if that's arrest or not, because it comes into what's reasonable, if somebody can or can't. And, some of my friends in the room probably and I might have a different opinion as to what an arrest is.
Okay.
In fact, I can hear a giggle or 2 about that.
Okay.
But that is something we routinely discuss, because there are times, and it varies from state to state as well, because in some states, the placing of handcuffs is an automatic decision, whereas there are instances here in Georgia where we've been able to argue that putting somebody in handcuffs is not an arrest. It's just a mere administrative detention.
Mm-hmm.
That's a debate to be had across the street in a different building.
Gotcha.
But
Okay. Thank you.
So did I understand you to express concerns about, I know you mentioned the peace officer versus law enforcement officer, but is there another concern about some of the language in the bill?
I'm just telling you what you're getting yourself into. I don't have any concerns. I'm just letting you know that this is the backdrop, like I usually do. And, this bill is a newly dropped bill. We don't have a position on it. I'm just trying to let you know this is the words you're using if you're wanting me, because in theory, if somebody's being arrested on behalf of if someone's being detained on behalf of a state officer, in theory, it's because it's a state criminal violation. A prosecutor in the state of Georgia is going to be handling that case, not a federal prosecution, more than likely. So how are we going to read it? How are we going to have to argue it to a judge? We're going to have one of them more than likely to come into our courtroom to testify about what they did, especially because somebody might make a statement, something might be found. So if they're going to be part of the process, we're going to need to be able to have access to them and have them come in and testify.
Well, but I'm assuming as a state entity, we are powerless to compel federal officer. I mean, are they subject to general subpoena?
I am not excused. So the 2E regulations are specific to when there's a subpoena that's issued by the state to compel a federal officer to attend a trial or a hearing. So yes, the state does get to issue a subpoena. The subpoena and the request by the law enforcement prosecuting team or defense counsel in that matter has to comply with the 2E regulations in order for the federal agent or officer to come.
And what regulate, are you referring to a specific section? You said two.
It's TOUHY. It's a
Oh,
federal case,
oh,
but
okay.
if you're asking, I am not as good as he is about trying to remember numbers.
No, that's fine. I was not familiar with that. I didn't understand to what you were referring. So that clears that up.
Yes, sir. So there is a compelling power. There are exceptions to the compelling reasons of why a federal agent or a federal officer would not be in compliance, and it's because it doesn't comply with 2E. That's why.
But as I do read the bill, this does require a request by a local official. So presumably what you're referring to would be sort of a matter of trial prep or witness attendance, but the local officer presumably knows or has some idea of those issues when he makes a request that they assist.
Officer asks, an officer wants someone arrested or needs the assistance and says, "Hey, go detain that person." FBI agent makes the detention in the process of making sure that the person is, doesn't have any contraband on them, doesn't have anything they shouldn't have, discovers contraband of some type. The defense moves to suppress. If the local officer isn't the one that found it and can't articulate what happens, then we would have to comply with 2E and ask nicely to have the federal officer come in to testify. If that officer is unable because of various reasons, then that contraband would be inadmissible.
It'd be excluded. Well, I look forward to the PAC seminar on the pitfalls of referrals and incorporating federal officers and everything. Representative Neal.
Yes, thank you. I do have a question for you. So I know we're moving another bill in reference to giving jailers permission to arrest. Does this also give federal law enforcement the ability to assist in the jail if they do some sort of transport or whatsoever?
Well, the way, it says right here, a federal law enforcement officer may detain a person upon the request of a law enforcement officer of the state or of any county, municipality, or other political subdivision of the state. Well, what does that mean? A law enforcement officer of the state, or basically is a law enforcement, or if the language law enforcement officer, if it includes jailers, then yes. If it doesn't include jailers, then no.
I'm trying to look that up. Okay, I'll look it up.
And I think, and I'm sorry, I don't know the answer right now. I'm sure somebody does in the room.
Okay.
Thank you. All right, any further questions from Mr. Smith? All right, thank you, sir.
Thank you.
Did you remove? Okay, all right.
Mr. Chairman, Rita Rocker, with the Parole Board.
Yes, please.
Thank you. I'm the Deputy Executive Director at the State Board of Pardons and Paroles,
And
and
state your name, that you're near in proximity to the microphone.
Rita Rocker,
Oh,
or
thank you.
IPA or OCKR. Just wanted to be sure that the committee knows that this doesn't just affect parole. If peace officer is changed to law enforcement officer, it also affects corrections and the Department of Community Supervision. So it's a little bit larger than parole. Just wanted you to know that. And we have no issue with the federal part of it. We're just concerned with the striking of peace officer further back in the bill.
So to answer Mr. Smith's question and our question, which is law enforcement officer, I guess, is the broader term than peace officer?
It is, and I appreciate our friends' help from PAC. The main difference, as I understand it, law enforcement officers have taken specifically mandated courses. Peace officers have not. So my understanding is that the law enforcement officers are specifically trained for on certain laws. Like as a peace officer, our parole officers cannot make a traffic stop. You know, they're not trained to do that, but they are trained in other areas of law enforcement. If you
Okay.
think about it, back in 1943, when the parole board originated, keepers of the peace is how how officers were thought of. So peace officers is where I'm supposing where that came from.
Okay. All right. So is it your understanding then that peace officer is narrower or broader, or is there not necessarily a correlation in that respect?
I believe peace officer is broader.
Okay.
So my understanding is if that language stayed the way it is currently, and let me give you a specific line. Like on line 83 or 79. If you just leave in peace and take out, you don't need law enforcement officer, then peace officers covers what peace officer would cover everybody. Is that right, Robert?
He's nodding affirmatively. Let
Yes.
the record
So
reflect.
that
Mr. Smith is nodding in the.
right. So it's pretty much on line 79, lines 83 and 86. And I do want to say too, that Representative Reeves has spoken with us and talked with us, and we've worked on it and talked about it. I just wanted to be sure everyone's aware of that. Just
And I think that's a
Doing my job.
conversation you're going to continue to have. I think for today, we want to grease the sides of the chute so the bill can keep moving.
Again, Representative Ken Vance, I appreciate his review of this along with Ms. Rocker, and the federal authorities have reviewed it. So post-certified law enforcement officers is one concept, but this is good sound language, and we'll continue working with them on that.
Okay.
thank you.
Thank you. Representative Neal, did you have a question, or did I just leave you real light on?
I think you left on, I was gonna give a code section 35-115, but it's not clarifying. I'm still trying to search for a definition for the body.
Okay,
I'm good.
thank you.
317 Georgia 659 2023 Georgia Supreme Court decision.
What was the citation?
State versus Cook 317 Georgia 659. The Georgia Supreme Court acknowledged that it's not defined in 17. They used the combination of Title 16 and Title 35. How will that definition together?
Okay. So I think the chair's concern is we may not be able to resolve that issue today. I'd like to at least entertain a motion with regard to the underlying bill. So the floor will your home.
Motion to pass.
I have a motion to pass in a second. Any further discussion? All those in favor signify by saying aye. Aye. All opposed, like sign. All right. Thank you very much.
Thanks so much.
And thank all of you for your attendance today and your service. Representative Draper, you want to go ahead?
She's also got somebody on Zoom.
Yeah.
Yes.
All right, Representative Draper, pick a microphone and I'll try to make sure I cut it on for you.
For Bill.
Is this your first visit?
It's my first visit with you all.
Well,
Yes,
welcome to
hello.
the Leverett Subcommittee.
Thank you very much. Glad to be here. So thank you for the opportunity to present this bill. This is House Bill 1118, and I am working off of LC 2979S. Okay. So this bill is about publicly saying that we support our election workers and backing our words up with common sense, targeted solutions for the very real challenges that they face. Solutions that have been adopted by states, both red and blue. Election officials and poll workers are critical to ensuring that elections run smoothly and remain secure. And they are frontline democracy heroes. They deserve not just our respect, but our active support. So there are certainly many national statistics that I could cite that would prove that there has been a marked increase in threats and harassments against our election workers. And you may hear about some of those statistics today because I know there's a couple people here to speak in support of the bill. But what I would like to focus on is our Georgia election workers and what they are experiencing. So across this state, they will tell you that tensions have risen. Our election workers have been yelled at. They have been called liars, traitors, and even more terrible names. They have been nearly driven off the road while transporting ballots. They have been threatened with violence and even with death. And they have been harassed on the job, and they have been harassed in their homes. And they have been swatted, meaning that they have had police come to their homes where they live with their families, putting their family members directly in harm's way. The incidents of threat and harassment and abuse have gone up, and we have every reason to believe that they will continue to rise as we enter into this contentious 2024 election cycle. Today, you will hear from two of Georgia's finest election superintendents, Chris Channel of Glynn County and Veronica Johnson of Lee County, who will be able to expound upon their experiences on the front line. And they are taking time away to be here during the middle of early voting to speak in support of this bill. And I don't know if the Zoom is set up. Yes, okay, great, perfect. So now turning to the legislation. I want to be clear that we're not paving a novel path here. We would be taking steps that other states have already taken, states like Oklahoma, Arizona, Nevada. So let me get into what the bill does. There's only 3 sections. I'll walk you through them, starting with Section 2. So Section 2 expands existing protections for poll officials to other categories of election workers. Basically, we're ensuring that everyone is covered. Everybody who works in elections is covered by the already existing protections that exist in Georgia law. Section 3 codifies that the personal information of these workers should not be disclosed. It protects their privacy. It makes doxing harder to do. We have literally seen open record requests to counties that ask for election workers, phone numbers, addresses. I mean, there's no legitimate public interest in getting that information. And finally, what Section 1 does is it creates a mechanism for reporting violations of existing law from poll officials, and it collects that information into a report that will be given to us, the General Assembly, once a year, so that we can calibrate policy solutions to be responsive to concrete and timely data. So I will close by saying this. This summer, we had several of our colleagues who were the victims of swatting. They had police show up at their homes, guns drawn, while they and their unsuspecting families were inside. And that's awful, because when you put yourself out there and you serve the public good, you know that it will involve sacrifice, but your peace of mind and your safety and the safety of your loved ones is not something we generally contemplate as putting on the line. And the General Assembly is taking action by responding to this new and very real threat. Yesterday, the Senate passed SB 421, which revises the punishments to swatting, and I expect we'll see that piece of legislation in the House soon. I'm very glad we're taking that step and taking it quickly to protect ourselves. I really am. And now I think it's time for us to do the same thing to protect our frontline democracy heroes. So I ask for your favorable consideration of this bill and would love to receive any questions if there are any.
Thank you, Representative. Just so on Section 2,
Yes.
you're taking an existing section that provides, I guess that it's a felony to prevent a poll officer from execution of duties, and you're just expanding that to include election workers and credentialed observers.
That's right. So poll officers, as it's defined now, really just covers the folks you interact with when you go to vote in person.
Okay. And are those terms either defined in statute or are they sort of terms of art that would have a general meaning?
Poll officers is defined in statute. Election workers is not,
Okay. And credentialed observer,
is not.
but I'm assuming there's a statute that
Deals
talks
with,
about observers having credentials in order. to be
correct.
elected.
And those are different than your public, they're public observers as well. Credentials observers is a much narrower category.
Okay. All right, thank you. Do we have, I know we've got a number of witnesses who want to testify to the bill, and we've got the two Zoom witnesses. Are there any questions of the representative before we move on to those witnesses? All right. All right, so how do we,
Computer audio, and then you can just follow in if Christopher Chanel looks like and Veronica Johnson.
all right, so I hit right there. All right, and then what do I do?
You can just let them know this, or they can start talking. Maybe call which one Christopher Chanel.
Sure. So is Mr. Chanel, can you hear me?
Yes, I can. Yes.
Well, thank you for being with us, Mr. Snell. If you'll go ahead, we can see you here and hear you. If you'll go ahead and just introduce yourself and your position and then give us your testimony.
Okay, my name's Christopher Channel. I'm the Director of Elections for Glenn County, Georgia. I've been doing this for about 6 years now, and I really appreciate the opportunity to talk with you guys today. This is something important, not just to me and my staff, but all my poll workers that I have that work for me in our county. The Representative Draper has kind of already covered the bill, so I don't want to go back and kind of talk about that. But the added language that basically looks like it's just extending the coverage to the election officials and the credentialed observers. On section, and I'm not sure which section it is that deals with the records of the poll officers and the availability of the home addresses and stuff to be shared out in open records request. Since 2000,
That's section 3.
yeah, we have been receiving a huge number of open records requests since 2020. And there's just absolutely no reason for this information to be handed out by the government or county entity to individuals that we know that the use of that information is only going to be for inappropriate purposes. So I did want to relate one instance where following the 2020 election, a member of my staff was in a local business. They got recognized by the owner of the business as an election worker because apparently they had been discussing the election prior to her walking in. And the owner of the business said, well, go ahead and ask her. She works with the elections department. And she did her business and walked in. 2 individuals followed her out of the building and made threatening comments to her about, well, if this doesn't get straightened out, we know who to come after. So even in a county like Glenn County, where we're a very strong Republican county, we're receiving blowback from the public for this type of behavior. If you guys have any questions, I'll feel free to answer them, but I think this is a great bill. It's at least a step in the right direction that will help me retain poll workers that feel threatened and do not want to work because of this type of threats and such.
Well, thank you very much for your testimony. Do any members of the committee have any questions for Mr. and its channel?
Channel, like a TV channel. Yep.
Okay, I'm sorry. I was trying to
problem.
make you a French origin. So, Matt, is that you?
Representative Draper, is he the gentleman from Lee County?
Oh, he's
Glenn County. Okay.
Right.
Well, that's even further. You didn't have to go through Henry County to get here. Thanks for testifying.
Yeah. Yeah. And my personal representative, Steve Saines is, I believe, on that committee, but he said he had to be at a different committee this afternoon to present his own bill to somebody else. So if you guys have any questions, pass them through him and he'll get them to me. Okay.
And that's fine. I'm sure he'll appreciate you highlighting his absence today.
Yeah. I'll whatever I can do to help him.
Thank you. Thank you very much. Appreciate the testimony. Let's see, who is our next witness? Veronica Johnson. Ms. Johnson, can you hear us?
I can.
We can see you too and hear you well. Thank you.
Well,
You'll go
thank
ahead
you.
and just give us your name and let us hear your testimony.
Okay, thank you. I appreciate the opportunity to speak with you today. I'm Veronica Johnson, and I'm the elections director in Lee County, Georgia, and I've been here for 24 years. We're kind of on the small side. We currently have around 25,000 registered voters. And as y'all are all aware, Georgia's become a hot topic for elections across the nation. And while Georgia election officials have continued to work to provide adequate and transparent elections for all Georgians, others across the nation have seem to have taken a keen interest in our election process here in Georgia as well. And as Chris mentioned earlier, the number of open records requests that we're getting following the 2020 election cycle have dramatically increased. And most of these open records requests that we're getting are coming from out of county and, more importantly, out of state groups, people that are interested in what's happening here. And the requests are evolving. They're not asking just for normal data on election turnout. They're getting into some little side areas that are getting a little concerning. So the need to protect transparency of the election process while ensuring the security of those involved needs to evolve too. And I applaud your efforts to protect those who work hard to provide service to our communities in our state. Now, as an elected official in a smaller but growing Southwest Georgia county, I can share most of our poll workers are longtime community servants. Our turnover rate for poll workers is not as high as it is in larger counties, but recruiting new poll workers is certainly becoming harder. Most of our workers are known in the community. They're typically working the precincts near their home and process voters who are their neighbors, friends from church, fans that they sit in the high school stadiums with at football games, and acquaintances that they chat with in the grocery stores. So while I feel a threat from our local community members is low, it's not totally non-existent. We've encountered threats of violence at a precinct, and we've certainly received our fair share of harassing mail and phone calls here at our local elections office. But because of our small size, my bigger concern lies in harm coming from outside sources. I believe with the number of groups nationwide utilizing email and Zoom and other forms of communication to spread concerns and misinformation regarding Georgia elections, I realize the personal information they're able to gain on our poll workers can be spread far and wide. So I realize that often the intent is just to harass and intimidate, and not necessarily to do harm. However, they do cause harm. They harm our ability to staff appropriately and to recruit and retain poll workers. It erodes the institutional knowledge that each county builds over years with seasoned poll workers and election officials. Anything we can do to protect those who continue to serve our communities and state with the election process is key. Workers shouldn't have to worry about repercussions for basically volunteering to help protect democracy and freedom in our country. So anything that you can do to help would be greatly appreciated. I'll be glad to answer any questions. Thank you.
Thank you. Thank you very much for your testimony. I think you have a question, Representative Reeves.
Is Representative Yurda your representative in Lee County?
He is, yes, sir.
He's working hard up here, and I appreciate your testimony. I've got family in America, so was there on Saturday, and y'all got a beautiful area down there.
Well, thank you so much.
Any other questions for this witness? Oh, I have a question.
Thank you, Mr. Chairman. I was just wondering how many of these requests have been either out of state or abroad? Just curious.
I would say, I mean, I am certainly no Fulton or Gwinnett or anything like that. I would hate to know what their numbers are, but there's not a week that goes by that we don't get some type of open records request. And I can honestly say without a doubt that 0 of them have come from a Lee County citizen, and most of them are coming from out-of-state entities. And I will tell you that during advance voting, especially in 2020 and 2022, the amount of phone calls that we were also getting from out-of-state entities were alarming. So California seemed to be a big one with us, and I'm sure other election directors can confirm that too. But we got lots and lots of interest from people all across the United States. California and Wisconsin were two that just baffled me. So calling constantly, wanting to know who was working, what our where our locations were and stuff, in the understanding that they were here to help our voters. So I think all of the Georgia counties certainly do a well enough job publishing information where advanced voting is and where the local precincts are, without having to have somebody from California or Wisconsin try to interfere in the process or aid additionally. So most of our open records request, well, all of our open records requests in Lee County have been from out of area.
Thank you. Thank you for your testimony.
You're welcome.
Thank you, Chair Lisa Cox. Any other questions? All right. Well, thank you. Thank you so much for your testimony. We're going to let you get back to work. Okay. It was a little bit late. Thank you very much. All right. We've got a number of witnesses signed up here. If you'll try to keep your comments brief, if you would. Is it Victoria Cruz? You'll come on up, Ms. Cruz. Yes, ma'am. If you want to testify, you need to, if you want to speak to us, we need to do that. So there's room. We got another seat up here, and I can kick her out if need be.
Placements don't always cooperate.
I would imagine. I haven't had them replaced yet, and the ones I got don't cooperate very well. All right, go ahead. Just if you'll state your name for us and tell us who you are, and then.
Yes, my name is Victoria Cruz and I'm from Athens, Georgia. I'm happy to see Judge Lawton Stevens. Oh, he's gone already?
He was. I know.
Actually
I was remiss in not introducing him, but
lives in our neighborhood. Yeah, I am here to speak against this bill. I just want to say that most states and the federal government already have existing laws which protect citizens generally and election workers specifically and electors from harassment, intimidation, and threats. I'm going to call that HIT for short. However, states are being urged to pass harsher penalties and stipulations across the country. Virginia going so far as to create a protected class for election officials and call the same offenses hate crimes. That adds a whole new dimension to the crime. Language in the bill would also allow censorship of free speech if it was felt that that speech was contributing to any form of election denial or election inquiry, or just, anyway, it would allow censorship. In other words, the social media company couldn't be sued. What we have here, and this is according to Cleta Mitchell, who is with the Election Integrity Network, is a threat narrative cottage industry. After 2020, but specifically starting in 2022, thanks to the establishment of the Committee for Safe and Secure Elections, we have an explosion of news media attesting to the fact that there are increased, ballooning incidents of hit. And this has been fueled by the hysteria off of January 6th. And we can all have differences of opinion about what January 6th meant and what the investigation done by the committee revealed or did not reveal. However, what we have now is this threat narrative, and I bring this is the handout from the Georgia voter registration and election officials conference that occurred in Athens recently. And new, I'm sure, because I didn't see it last time, new on this thing are active shooter response training. Okay. Also, let's see, de-escalation training, which I would think would be very helpful. De-escalation. I hope we never see an active shooter, but an election crime breakdown with the FBI there. What I want to bring forth is that I was very surprised after 2020, like most Americans were, thinking a result was in the bag and then awakening the next day, not only to a different result, but also to viral social media about all the things that were going on. So what did I do? I responded to a request to poll watch at the 2021 Senate runoff. First time ever in my life in DeKalb County. And I'm from Athens and Oconee County. And although I was terrified, I went. And what I experienced there was being told to sit down far from where everything was happening and not talk to anybody, not say anything. And of course, my training wasn't very good either. That was very intimidating to me, you know, as an, you know, elderly person. And I'm just afraid that the real intent of this bill is to keep citizens and poll observers from meaningful observation of elections. I had a lot to learn in 2020 about how our elections went, and I had a lot of questions to ask. And I was fortunate in Oconee County that my elections officials were very friendly and outgoing about answering my questions, about letting me observe logic and accuracy testing, just giving me, and of course, when I started poll watching there, we had laws then in place to ensure that I would be able to go where I needed to go, and had a great relationship with them. What I've noticed over the last year or two, though, since this threat narrative has started, is that they are more defensive. I know they don't like open records requests, so, and I don't like to send even things I want to know. I did send one about threat, harassment, intimidation to Oconee County and Athens Clarke County. There were no reports of that. And I can leave this with you. This is an actual report from the Department of Justice, the Assistant Attorney General, saying that in their first survey of this, and by the way, the surveys were sent out by the Brennan Center for Justice, surveying all across the country. Tell us what happened to you. And so they got 1,000 in that first round of surveys. It's been every year since then. Of those, approximately 11% met the threshold for a federal criminal investigation. The remaining did not provide a predication for federal criminal investigation. The contacts were often hostile, harassing, and abusive toward election officials, but they didn't include a threat to violence. And not only that, they say that 50% of the matters the source contacted the victim on multiple occasions. So these contacts, that was included in the 1,000. So we have less than 5% of reported contacts being associated with something that rises to the elevation, and only 14 cases prosecuted so far. So I think that it is inflated. I think that there are laws already in place to take care of this. And I think that this bill, although I'm glad they put in poll observers, I'm so glad they did that, because there have been issues against poll observers. What I do want to bring to your attention, I'm going to leave it with you. This is harassment and intimidation to me. And if you can read it, it's a report from Informing Democracy, a spotlight on 204 officials who could undermine our elections. And that includes election workers, election directors. So I'd like to leave that with you. I can also give you the, I'll get that to you. Also leave with you the general. Thank you so much.
Thank you so much for your testimony. I appreciate that. Pamela Reardon.
There's a dog there, so I just wasn't a big dog.
Pretty dog.
Pretty dog.
Well-behaved dog too.
Yes, yes.
All right, Ms.
Okay.
Reardon, if you'll just introduce yourself and.
Yes. My name is Pamela Reardon and I live in Cobb County. I have been poll watching since 2008. Probably before that, but that's the first time I remember. I have never, ever had a problem. And of course, I've been very, very nice all the time. And I've trained poll watchers. But this bill, I think, is highlighting something that isn't a problem. And the thing that, and I have to apologize, I didn't see the latest version, which you just brought up. But the one that I read, a 5-year prison sentence. I mean, we had 15,000 people in Cobb County in 2020 who voted illegally. Nothing was done. And that is just something that takes away my vote, all of your vote, if somebody votes illegally because they admitted they moved to another state. And so until those come in line and then people realize that, no, you can't vote illegally. You can't move to another county and vote from that county. You can't move from your state and vote in that state still. Then I think that this is really blown up out of proportion. I mean, is that not what it said? 5-year prison sentence? Well,
That's
yeah.
1 to 10, but that's current.
Yeah. So, and I know of a poll watcher who was threatened by a voter in Fulton County in 22. So this goes both ways. And I'm really glad that you did include poll watchers in there, because what we are doing is we're just watching and we're counting. You know, we're watching and we're counting, and we just want transparent, fair elections. So those are just my comments. Thank you very much.
Thank you for your testimony. I don't see any questions.
Oh, sorry.
I don't believe there are any, but thank you. Is it Stephen Elishire?
Thank you. My name is Stephen Elshire, Athens, Georgia. I am not in favor of this bill. I've been a poll watcher or observer multiple times and in multiple counties. These experiences have always been uniformly peaceful, polite, non-threatening events. Maybe I wasn't in the right jurisdiction. The most exciting thing that occurred at one time was when a ballot marking device was not reset to 0 on election day, and another time when the wrong paper was loaded. But beyond that, nothing interpersonal with humans occurred. Recent national and state surveys of election workers, to echo what was previously said by the previous two, including FOIAs of Georgia counties, do not show reports of alleged or actual violence. Actually, I know of threats against poll observers for their mere presence in the room. The roots of this violence narrative go back several years to the so-called fentanyl letters, which occurred out in Washington State when Antifa and other activist groups apparently sent fentanyl-laced letters to election directors to demand an end to state elections. Ironically, this narrative has now been turned in the opposite direction to people who merely want to observe or participate in the election process. The penalties envisioned in this bill are so extreme that they will chill all hopes for further election integrity and will cast doubt on election legitimacy because no one's there to watch things. The bill will decimate poll watcher and worker participation for fear that any remark made, no matter how seemingly innocent, might get them into felony level legal troubles. I know I don't want to go there. The definition of violence and election worker interference with duties is broad and ambiguous. Any misinterpreted words could be construed as so-called violence. Finally, the public narrative that polling locations are violent places to be feared and don't go there to vote will work only to encourage people to start using mail-in ballots again, and we know about drop boxes. Please do not vote in favor of this bill. Thank you very much.
Thank you. I think we have a question. Representative Reeves?
Are you from Clark or Oconee County in Athens?
Oconee County.
Oconee, all right. That was, that sort of messed up my theory. Lee County went as much for Trump as Clark County did for Biden in 2020. And we've got Lee County and Clark County on kind of opposite sides on the testimony today. But anyway, you're from Oconee, so.
Thank
Yep.
you for your testimony.
Thank
you. All right, Peter Simmons. When you're ready, Mr. Simmons, just introduce yourself and tell us who you're with. And
Yes, sir. Esteemed members of the committee, my name is Peter Simmons, and I'm the Georgia State Policy Strategist for Protect Democracy. We're a cross-ideological nonprofit dedicated to defeating authoritarianism, strengthening democratic institutions, and preserving freedom and the rule of law. We are encouraged by HB 1118's meaningful protection for Georgia's election workers because our state cannot sustain the burdens of securing our elections and preserving our democratic republic without the neighbors, friends, and family who choose to be election workers. Despite their importance, a national survey of almost 11,000 election workers last year showed that 21% of local election officials were considering leaving before the upcoming election. 30% had been abused, harassed, or threatened, and nearly 3 out of 4 believe threats have recently increased. This data demonstrates that the people who make free and fair elections possible are enduring real, regular threats that can be deadly serious for election officials and their families. This is unacceptable and it's unsustainable. We have identified several policy solutions adopted across the nation that attempt to resolve this issue by limiting opportunities for bad actors to take anti-democratic behavior while empowering election officials. These include privacy protections, prohibitions against intimidation, harm, and harassment, civil remedies, adequate security funding and training, and the collection of and increased access to data related to threats that these officials face. HB 1118 addresses 3 out of 5 of these areas. First, the bill provides meaningful protections for election officials' private information. As many members of this assembly have found out, unfortunately, in the last few months, exposure of personal information is not a risk that is limited to election officials or any one member of any particular political party. Swatting and other forms of harassment are incredibly harmful to our democratic institutions and damage the victim's ability to effectively execute their duties while discouraging prospective election officials from taking up this valuable, vital work. Though we also appreciate the bill's nuanced approach to accountability and updating existing prohibitions to cover more election workers without increasing penalties. This bill will take a measured approach that will pursue accountability and deter future violations. However, we do suggest that the committee amend this bill to include civil causes of action that will allow election workers injunctive and other forms of relief so they can protect themselves without needing to rely on others. Finally, we really appreciate the robust data collection efforts included in this bill. Most of the information that policymakers are receiving come from journalists and nonprofits like Protect Democracy. This is incredibly important information, but it's incomplete. States can play a very important role in protecting these officials by collecting and analyzing data related to these threats and using this data to calibrate appropriate state solutions and helping to ensure adequate visibility into how we are prioritizing this issue. These are invaluable steps that we can take to ensure that the individuals who are responsible for protecting democracy in Georgia have the security necessary to execute their duties impartially and without fear of retribution or political violence. Thank you very much for this bill, and we hope to see a data-driven, bipartisan effort continue around this issue. Happy to take any questions.
Thank you. Thank you. I believe you have a question. Representative Neal.
Yes, ma'am.
Just a quick question, and based on what I'm seeing, but this bill doesn't prevent poll workers from bringing civil suit, right? Correct?
No, not at all.
Okay. Okay. Thank you.
Thank you. Any other questions for this witness? I don't see any questions. Thank you very much. Appreciate your
Thank you, Mr.
testimony. Is it Rachel Lastinger?
Thank you. Good afternoon. My name is Rachel Lastinger, and I'm the Associate Director of the Voter Access Project with the ACLU of Georgia. The Voter Access Project works to ensure that voting is easy and accessible for all Georgians, and I'm here today to speak in support of HB 1118. Given the changes in the substitute bill, the ACLU of Georgia thinks this is a good preventative measure to protect election workers. As my colleagues have already stated, sadly, it has become increasingly necessary for legislation to exist that works to protect election workers from the increasing threats and harassments that they are facing. Violent threats against election workers have reached alarming levels, and according to a Brennan Center report, 1 in 3 election officials feels unsafe because of their job. Nearly 3 in 4 feel that threats against election officials have increased in recent years, and nearly half are concerned about the safety of their colleagues and or staff. So we know these problems persist in Georgia as well, and in recent election cycles, we saw direct threats against our Secretary of State and family, as well as multiple election officials. I personally know many of these election officials and can attest that their stories are real and that their stories are very emotional. Most legislation which seeks to address these issues are simply reactive, while HB 1118 seeks to be proactive. In Section 3, the bill introduces greater protection of personally identifiable information for poll officers, election workers, and credentialed observers. Many election workers have had their home addresses and phone numbers shared on the internet and have received threats directed at them and their families. The best solution is to allow election workers to request the removal of their personally identifiable information from government databases, such as is being proposed now in this bill. By passing this bill, we will join the growing number of states that have already accomplished this through legislation such as Colorado and Arizona. So I'll end with saying that in that same Brennan Center report, only 54% of the surveyed election officials say their state government is doing a good job supporting them in their roles. So let's work to increase that percentage in Georgia and show that legislators do support them and want to take steps to actually protect them. Thank you.
Thank you. Thank you for your testimony. You have any questions for this witness? I don't see any questions. Thank you very much. Is it Lana? And what is the last name? Goitia Paz.
It's okay.
I'm glad I didn't try that. before
That's
you
all
gave
right.
it to me. Thank you for being here today.
No problem.
Just go ahead,
Okay.
state your name, your organization,
Okay.
and then give us your testimony.
Hi, everyone. My name is Lana Goitia Paz, and I'm with the I'm with All Voters Local Action. I am their Georgia campaign manager. We are a nonpartisan organization that advocates for policies that will improve voter access and aid counties in running smooth elections. As we gather here today, it is imperative that we recognize the importance of protecting the individuals who serve as the backbone of our elections, our election workers. These dedicated individuals play a vital role in ensuring that our elections are conducted smoothly and fairly. However, recent events and open records requests for personal information related to election staff have highlighted a disturbing trend of violence and intimidation directed towards these individuals, threatening their safety. I will point out too that this bill also goes as far as to cover credentialed poll watchers, which would provide additional protections for them while they are at polling locations, which I think actually encourages more poll watcher participation rather than hindering it. House Bill 1118 sends a clear message that such violent or intimidative behavior will not be tolerated in our democratic society. By passing this bill, this body makes a statement to those who seek to disrupt our elections through violence or threats that such acts will not be tolerated in our state. I want to point out that this is not just a matter of personal safety for our election workers, but also a matter of election integrity. It is imperative that we take decisive action to ensure public trust and confidence in our election system. And a crucial component of that is making sure that those that conduct our elections are protected. Every eligible voter deserves the right to cast their ballot freely and without fear, and every election worker should be able to carry out their duties without risk of harm or coercion. I urge each and every one of you to support this bill. Let us send a strong message that violence and intimidation have no place in our elections and reaffirm our commitment to the election workers across the state of Georgia. Thank you.
Thank you for your testimony. I think that's all the folks have signed up. Is there anyone else here who wants to speak to House Bill 1118? Yes. We know who you are, but tell our audience at home who you are and then give us your testimony.
Thank you, Mr. Chairman, members of the committee. My name is Marcy Rubinson, and I represent the Georgia Association of Voting Registrars and Election Officials. We appreciate this legislation. We think it will go a long way towards ensuring that we can recruit and maintain election officials and poll workers and ensure a safe election system.
Thank you. Any questions for this witness? All right, thank you. Don't see any. All right. Oh, Representative Neal? Okay. Representative Draper, did you want to kind of do a closing statement or any kind of finish, or you wish to say anything further?
Yes, sir. Just appreciate the consideration of both.
Okay, all right. Representative Neal?
I move.
All right, we have a motion do pass. Do I have a second?
Second.
I have a second. Did you wish to say something?
Yes, Representative Draper, have you seen the civil cause of action proposed amendment? Are you okay with it? It might help.
That doesn't look like the faithful.
It might help recruit poll workers. It's up to you. Well, you're the author. If you think it would fit in with the bill and help it, I'm glad to move for an amendment, but I don't want to do anything that's not friendly to the bill. Sure. Okay.
I guess her position is that that's a type of election worker as well. Just
If we're gonna do that, then you probably want to hear them, right? It's for election workers that it matches.
yeah, I guess so.
Just for clarity.
Sorry, we were chatting about my analyst was noting that the language, so on line 36, it references an other election worker, and then later down on 39, it does not retain the other. So my thought was maybe the other should go on there. All right, so I've got a motion and a second. Do I have any amendments? No amendment from Representative Reeve. All right. Do we wish to add other on line 39 to make it consistent with the way the word appears on 36 and 37, other election worker? Okay.
Yes.
All right. So I've got a motion to amend by adding the word other right before the word election on line 39.
Second.
I have a second. All right. So let's vote all in favor of the amendment of the Silcox amendment, signify by saying aye.
Aye.
All those opposed? All right, so that passes. Now let's vote on the bill as amended. All in favor signify by saying aye.
Aye.
All opposed? All right. Thank you. Yes, ma'am. Subcommittee technically, but I appreciate you giving me the promotion. All right, let's see.
We got 3 left.
You ready to do your bill?
Yes. Thank you.
You can walk around, or if you, well, at this point, you've already gotten there. I'm sorry. I just said you could stay at your seat if you like, but I was a little slow on the uptake. And I meant to ask, what is the name of the canine attendee today? Hershey. That's a beautiful dog. I know you're proud of it. Or is it a she? It's a he. All right, Representative Crawford, you have the floor, sir.
All right. Thank you, Mr. Chairman and members of the committee. I'm here presenting House Bill 1110, and I'm coming from LC 481092. And this bill proposes to tighten up some language. What it's doing is to amend OCGA 16595, the criminal code section for the offense of violation of a family violence protective order, to insert language that would also establish the offense of violation of a dating violence protective order. Right now, if you look at OCGA 1913A6, it references the criminal code, providing that a violation of an order issued pursuant to this chapter may be punished by an action for contempt or criminally punished as provided in Article 7 of Chapter 5 of Title 16. But at the time, when dating violence bill was drafted and enacted, it didn't simultaneously amend the criminal section code. So right now it's actually illegal. I'm sorry, it's not legally possible to charge someone or hold them in contempt for violating a dating violence protective order, because at this moment, no such offense exists. So only thing this bill is trying to do is tie up loose ends that was left out of language in OCGA 1913A6. Is not changing any definition. It's just, again, making sure that the language aligns.
So I'm going to use my chair's prerogative here and ask a question too. So I gather dating violence, that concept has been added to the stalking or family violence, the one where you can get the order, the protective order.
So dating violence is I hope I'm answering your question. It's already defined in 1913A, OCGA 1913.
Okay.
So there's already a definition for it.
So
but
that's a concept that already exists in code.
Yes, it already exists in code. And so what this is doing is just aligning the language to make sure, because right now, again, legally, there is no legal possibility of violating a dating protective order. So it's just making sure that the purpose of creating dating violence now can actually go into effect.
I see. So you're not necessarily creating the crime of dating violence, but you are giving as the basis of a protective order an act of dating violence or protection from that.
Correct. That is it.
See, I can be taught. That's like whatever it says. All right. And I didn't mean, I kind of interrupted you.
No.
Anything else?
Thank you. Thank you.
Okay.
And I have some people that wanted to.
Yeah, I know
speak
we've
with it.
got
I
a
don't
few
have-
folks signed up here. But are there any questions for Representative Crawford? Representative Neal.
I was gonna make a motion, but if you want to give the
Well, we've
speakers
got some
time.
folks who are here to testify, so I will rule you out of order, Representative Neal. All right. Let's see. Let's see where we 110. I think Annie Jordan. And you can sit at the other chair, so you don't have to do the musical chairs like the federal agents did. Yeah, that's fine. All right, if you will just state your name in the microphone, tell us your organization, and then let's hear your testimony.
Yes, I'm Annie Jordan. I am the executive director of DeKalb Pro Bono, but I'm here on behalf of the Georgia TPO Forum. We are a statewide collaboration of attorneys and domestic violence advocates who are in the trenches every day helping people escape abuse. We meet regularly, and I wanted to express the forum's support of this bill and impress upon all of you what this bill means. There's no easier way to say it other than dating violence TPOs are largely meaningless without any sort of criminal enforcement mechanism. That's a mechanism that exists for other types of protective orders that are already that have been in existence for a long time. And it seems like it's just an oversight that that the criminal enforcement mechanism didn't carry over to the dating violence protective order statute that was passed recently. So like I said, I want to express our support and tell you that this is a really important way to prevent violence in our communities and to protect people who have experienced abuse. And to press upon you how valuable these sorts of orders are because of that criminal enforcement mechanism. I recently saw a CDC study that referenced a study that found that protective orders can curb violence by up to 80% over the length of a permanent or 12-month protective order. So this is a very effective way to prevent violence before it happens, and we'd ask you to support the bill.
Again, just to make sure I'm understanding, we're adding a definition of dating violence to the criminal statute on violating a family violence order, and then providing that violating an order that pertains to dating violence is now a crime.
Yes, correct.
Okay. All right. Thank you. I'm sorry. Any questions for this witness? I don't hear. Thank you very much for
Thank you.
testimony. Is it? I'm not sure. Karima. Sorry, Karima. Ms. Dillard, please come up. Okay. All right. Well, thank you. I noticed you're signed up for another one, so hopefully we'll get to hear from you on that one. Is it Charlotte Jackson?
Yes.
Thank you for being here.
Thank you for allowing me to speak. I'm Charlotte Jackson. I'm the Prosecuting Attorney's Counsel. I am the Domestic Violence and Sexual Assault Resource Prosecutor. I do training, technical assistance, prosecution of domestic violence and sexual assault crimes. This bill is especially important for enforcement purposes. We can talk about dating violence, domestic violence all day long. One of the things I hear about the most is getting protective orders enforced and how difficult it is to get law enforcement officers to enforce protective orders. Theoretically, 1913 1A does have language that says it can be enforced under 16-595, but honestly, unless it is written there in that Title 16, law enforcement officers not going to make that arrest. And we're putting our victims in the position of not just having to fight their abuser for their safety, but also to try to persuade a law enforcement officer to make an arrest. And we don't want to put them in that position. It'll make it easier for prosecutors. And so I think this is a good strategy.
So I'm assuming PAC supports.
Yes.
Okay, great. Any questions? I don't see any. Thank you so much for your testimony. Appreciate that. Let's see. Maisie Lynn Maisie, how's your last name pronounced?
Like Curtin, but with a G.
Girton. Okay, Girton. Thank you.
I'm sure a lot of people wanted to ask that. Thank you for clearing it up for everyone.
Well, I've heard it, but I just suddenly was insecure about the way to pronounce it, so I figured I'd just ask.
Okay.
So,
Maisie Lynn Girton, Executive Director at the Georgia Association of Criminal Defense Lawyers. And I spoke briefly with Representative Crawford before the hearing today. And for those of you who were here when Representative Gaines brought the dating violence concept to the table, you'll remember that a lot of time was spent defining what a dating relationship is. Unfortunately, the definition did not carry through to this bill. And so in a friendly way, I would just suggest that at line 20, either a reference to that definition, which is held in 19-13 capital A-1, be dropped, or as has been done here, the entire definition of dating violence was pulled from 1913A and placed into this bill. The same thing could happen with dating relationship. And as much as I would like
what's
to,
that? 19?
yes, 19-13 capital A is the chapter.
The chapter, okay.
Mhm. And then it's in code section 1.
Okay.
Just so that there's clarity that we're talking about the same kind of dating relationship you guys worked so hard to define. And I would be remiss if I just didn't name for the record, we continue to be concerned about the expansive definition of any felony, but we understand that we are here using that in lines 21 and 30 because that is what's in 1913A1, and there are many nonviolent felonies that can be used in this context. Sort of offensively against a victim of domestic violence. So as much as we'd love to ask you to narrow it, I don't know that there's a practical way to do that. There wasn't then, and I don't think there is now either. Any other questions for me?
So
Or any questions?
I'm trying to, hold on, Brian, I'm gonna pull it up here because I can't read that far. All right, so we're. Go ahead, floor leader Hong.
And I think you're probably looking this up, Chairman. So are you stating that line 18 through 20, that is the same definition as 1913A, or are we missing certain?
No,
words?
so the lines 18 through 20, actually lines 18 through 22 match the definition of dating violence that is now codified in 1913A1. Paragraph 2. What is not cross-referenced in HB 1110 is the definition of dating relationship, which is included in the definition of dating violence, which is the first definition in 1913A1, paragraph 1. So it'd be.
And dating relationship that's on line 20.
Yes, ma'am.
Okay, and so you would want us to reference that code section for that definition? Is that
Right.
what you're
That
asking?
That would be ideal so that we just are because otherwise, kind of like the conversation that happened earlier with law enforcement officer and peace officer, Title 16 does not have a definition of dating relationship. It's held in Title 19. And so referring back would just bring that definition into 16 in the same way. I mean, dating violence could have been done that way too. It doesn't matter. It's listed out here. So the alternative would be to list out the same matching definition of dating relationship.
And thank you. And Representative Crawford, would that be a friendly amendment? Thank you.
Thank you for your consideration. Anything else, Chairman?
Brian's pointed out to me that the dating violence order definition refers to Article 1 of Chapter 13 of Title 19.
Which I believe.
Is that correct?
Let me look.
Dating violence is under 13.
It's in 13A. It is. So that's a scrivener's error too.
So we're not asking for motions at this time, but just to make sure that the chair, who is old and sodded, understands what we're talking about, is it just adding at the end of line 20 after the word "in a relationship" before the colon, as defined in, just a reference to the statute.
That would be fine.
Okay.
Yes. Efficient.
On
On line
line 20.
20, dating relationship as defined.
Dating
in-
violence definition starts in 18, but it references to dating relationship, which is also statutorily defined in code. Right. 19-13A-1 paragraph 2.
I mean, it was just a choice, and I would believe, and I don't want to, I would believe there's a choice in drafting. You can pull what the choice here was, just to pull the entire definition over. It does mirror. It could have been done as a reference. It just was, it's 6 1, half dozen the other kind of a thing.
You can just add like a new definition here, just say dating relationship and have it match exactly what's in 1913A1. That way, so it's the same definition.
Yeah.
But you don't have to worry about it's defined in the code section after dating relationship, because there's 2 elements after it, or 2 ways in which you could apply.
And I don't know if, I don't see legislative counsel, but in the future, should one or the other of these code sections be amended in a way that impacts other references to those same concepts? Maybe one or the other is preferable. Maybe the restatement of the definition is preferable. Maybe the code section. That would be the only thing that catches my eye around future, making sure.
The chair was just thinking, for purposes of amending something on the fly here, it might be easier the shorter and the more succinct, the better.
Right.
I'm kind of leaning toward, in a dating relationship as defined in, but anyway.
But
Shipman.
also that, to your point, line 24, would need to be chapter 13.
I don't have a mic. I don't think this one works. Yeah, that was just going to concur with you. I think that referring back to the other one, that way, if you only got one that changed, if it's restated completely in this other code section, then you've got to go try to find everywhere it's stated. I think it's easier just to refer back to this. And even dating violence, instead of restating the whole definition here, you could just put dating violence as listed in 1913A1.
Sorry.
And not redefine either one of them here, just refer dating violence and dating relationship back to the original definitions in 1913A1. That way you don't have to worry about finding them and fixing them and have conflictions.
That's true. I was just trying to keep the changes to a minimum here so that things can get revised quickly and keep you moving. So
that's also true.
Yeah.
Time is.
But thank you for bringing that to our attention.
Anything else?
I don't see any other questions. Thank you very much. You play one on TV so well. Let's see. Yeah. All right, so Ms. Jackson. Did anyone else want to testify on this bill, on House Bill 110? I'm sorry, 1110?
Yes, Chairman.
Oh, I think so. Is that number 1 over there? All right, let's see if it works.
It appears so.
Okay, good.
Good afternoon. My name is April Ross. I'm the Executive Director for the Georgia Commission on Family Violence. We're the state agency that was charged with the state plan to end family violence in Georgia. And we worked with Representative Crawford as well on this bill. And we just want to express our support for this needed change. Many people oftentimes say that protective orders are just a piece of paper. Well, without this change, a dating violence protective order is literally just a piece of paper. So we clearly need to make this change. It was intended from the beginning when we worked with Representative Gaines to create the dating violence protective order. What happened was that we initially drafted dating violence protective orders into the Family Violence Act, which was 1913 one in that code section. But it ended up towards the very end being carved out into its own separate code section, which is how we got 1913A. And so we did not make that simultaneous change to the criminal code section because of the last minute carve out. So we're just trying to correct what was not kind of caught in that last minute time.
Thank you. Any questions for Ms. Ross? I don't see any. Thank you very much. Yep, that's actually, that's what they say. That's the reason we meet every year, is to fix the things we messed up the year before. So, all right, any other witnesses on 1110? All right, so the chair will entertain a motion.
Do pass.
Got a motion to pass. Representative Elsar, she beat you to it in a second. Do we have any amendments?
I do.
Floor leader, go ahead.
Thank you, Chairman. On line 20, after relationship. And before the colon, insert as defined in 19-13A paragraph 2. So 19-13A2. I'm sorry. One. So so as defined in 19-13A1 colon.
Well,
Yeah.
you probably want to add that paragraph 2 as well. 19.
No, just trying to define because it's comma with a relationship as defined. They wrote out the actual definition.
Oh,
Yeah.
I see.
Yeah.
So it'd be 1-1.
1913A1 paragraph.
One, correct.
Yeah, okay.
You could just reference the code section. I think it's fine.
Correct.
I like to be more specific.
Yeah.
So, all right, so we've got that amendment. So I guess let's go ahead and vote on that one all. So we got a motion to amend. Do I have a second? Have a second. Then I'll let you give them in that time. So any discussion? All right, all in favor?
Aye.
Aye. All right, any opposed? All right, do we have any other amendments? Maybe like on line 24? Where we want to add a capital A there after the 13? The chair will entertain a motion. Yeah, the reference is to chapter 13. It should be 13A. All right, floor leader Home.
Yes. And I'll, on line 24, after 13, add the letter A, capital A.
All right, that's, we got a motion. Any seconds? Have a second. Any discussion? All right, all in favor signify by saying aye.
Aye.
All opposed? All right, so we've got those two amendments have been made. Now let's go back to the bill as amended. We've got a motion and a second. Any discussion? All right, hearing none. All in favor signify by saying aye. All opposed? All right, thank you.
Thank you.
Congratulations.
Thank you.
Okay. Is Representative Bell? There it is. All right, so this is House Bill 990.
Yes, sir.
All right. Is this your first appearance before?
This is my first appearance before the civil non-judicial.
Judiciary. Well, this is the subcommittee, so we're glad to have you. Go ahead and just tell us about your bill.
Okay, thank you for the opportunity to present this bill. HB 990 serves to protect the economic interests of artists, creators in the $33 billion industry in our state by ensuring that artistic expression cannot be used against them in court. By making art inadmissible as evidence, this bill creates guidelines on how to treat creative work in court and in criminal settings, therefore safeguarding the artist's livelihood and promoting thriving artistic communities. Additionally, by providing clear guidance and guidelines, HB 990 makes it easier for judges and juries to navigate cases involving artistic expression, reducing confusion, and ensuring fair treatment under the law. Furthermore, HB 990 upholds the principles of the First Amendment by protecting individuals' rights to freedom of expression without fear of legal consequences. Both the First Amendment and common sense tells us artistic expression is a form of speech and should be protected as such. Moreover, HB 990 guards against a slippery slope scenario where artistic expression could be used as evidence in cases in increasing numbers and situations. There's a prominent case of overreach in Fulton County right now. One esteemed artist has figurative lyrics, ready like war, like Russia, and I have all types of cash. I'm a general, placing an indictment as an overt act of furtherance of conspiracy. There's obviously not literal statements or admission of any type of crime. It's been admitted into trial. We need to create better guidelines to prevent future cases of overreach. In closing, 990 stands as a formidable defense of artistic rights. Identical language has been passed in Missouri last year by their House. The GOP Speaker of Louisiana introduced a bill with the same text, and it's a deeply reasonable standard that balances public safety, freedom of speech, and protects the economic interests of our state. Thank you.
Thank you. So if you don't mind, kind of walk me through, are you creating a sort of an initial proffer that's got to be made outside the jury to determine if the evidence should be admitted or will be unduly prejudicial?
Can you repeat that for me?
I don't know if I can. In other words, it looks like what you're doing is you're sort of setting up a hurdle that a prosecutor would have to satisfy in order to admit into evidence some work of creative artistic expression as evidence of intent.
Not a hurdle, but guidelines to create unreasonable doubt.
Well, it looks like there's got to be an offer of proof.
Yes.
So I wasn't using hurdle in the pejorative term. I mean, it just creates a step for the court to assess the evidence first before it's presented to the jury. Okay. Florida Hong, I think, is going to clear me up on this.
Thank you, Chairman. And I do have a concern. I understand your intent, and I think this may be kind of similar to what Chairman is discussing. Are we doing an exception to the evidence code through this bill? So essentially stating that creative or artistic expression is not admissible. And if it is a creative or artistic expression, then correct. That it is, and I can't repeat what I just said either. But no. Let me think of that question, but that's kind of the line of reasoning that I'm going at. But Chairman may actually have a better way of, we're kind of, we have one brain today.
Well,
So I'll return it over to the chairman real quick. Thank you.
Thank you. Representative Neal.
Yes, thank you to the chair. So I guess the question would be, under this bill, are there instances where artistic expression can be used if necessary?
Yes, ma'am. They absolutely are.
And can you say what those instances are?
The council will help me with those instances.
Good afternoon. Thank you for meeting with us. My name is Shay Lawson. I am an Atlanta-based intellectual property and entertainment attorney. I'm here in my individual capacity, but I will also state that I sit on the Board of Governors for the Atlanta chapter of the Recording Academy, the Advisory Board for Songwriters of North America, and I chair policy for the Black Action Coalition. However, I'm here in my individual capacity as an attorney.
Good to have you with us today.
Thank you for hearing this bill. Yes, there are instances. And so just to be clear, this is not removing the ability to use creative expression in trial. However, it is creating a four-part standard for judges to be able to determine its relevance. So it does not have an automatic presumption of relevance, because we know that creative expression is largely imaginative, whether it's books or movies or television programs. And so those four parts are actually found in the bill on lines 30 through 35. And so we have that the defendant intended to adopt the literal meaning of the work as their own statement. We know oftentimes that artists have songwriters and other individuals that help them compile the lyrics. Two, that there's a strong factual nexus indicating that the creative expression refers to a specific act of a crime. And so if there is, let's just say, a lyric or a line that has to do with money laundering that is presented, but there is no actual charge of money laundering, we need there to be a tie to an actual crime that is alleged, that there exists relevance to an issue of fact that is disputed. So again, this cannot just simply be added as character evidence. We need to understand that there's a fact that's in dispute that this creative work will speak to directly, and that there's distinct probative value that's provided by other admissible evidence. And so to unlawyer that, it means to say that there is evidence outside of just this lyric that ties all of this together, that we have a fact, the crime that is committed, we have a lyric that directly speaks to a crime, or creative work that directly speaks to a crime that's committed. And then maybe I also have something that's probative, like a picture or a video or a telephone call. So it's really setting a standard, much in the way that medical evidence, we can't just ask a jury, look at this x-ray and tell me what it means. That's really what we're asking the court to do here for all artistic expression, not just music.
Thank you. So so as I understand it, you're creating a presumption of inadmissibility for any evidence that would satisfy the definition of creative or artistic expression, which is set out in the statute. First of all, correct?
Correct.
Okay. And then you're creating, basically requiring that there be a offer of proof outside the hearing of the jury where this evidence would be presented to meet that four-part standard. The prosecution would have to meet that four-part standard in order to get it admitted.
Correct. And this is in line with the Georgia Rules of Evidence 406 and 407, and also that with expert testimony in 702 and 703. So it's not anything new or adding an additional burden to the court process. It's in line with other types of evidence that have nuance and particularity.
What, and I'm sorry, I can't cite my rules of evidence like you can. What is 406 and 407? I think the ones you mentioned.
406 governs when evidence of habits of routine are admissible, and Rule 407 governs the admissibility of subsequent remedial measures. 702 and 703 refer to the admittance of evidence from experts, whether they are actual professional experts or lay witnesses experts. And so in this situation, we know often that there are nuances behind art. All of us have been to the High Museum and maybe had different interpretations of what a different film was or a piece of art was, or we watched a movie and we all got different meanings from it. The same way two different coroners could see something, or two different surgeons. We're asking for a very similar standard here for art.
Is the standard similar in that the structure of the hearing, the presumption is standard, or are these four criteria, that language that's been borrowed from those other rules?
No, this language is specific to this particular nuance of artistic and creative expression, much as the other rules are specific to those particular nuances.
Okay, I think I'll follow you. Is this something that, I mean, did y'all get the language from another state, or is this something you sort of, created
Oh, yes, Chairman. So this actually mirrors federal legislation that is being brought forth. There's actually a number of cases in the Second Circuit and the Sixth Circuit as recently as last month, where federal judges are asking for a codification of guidelines. They're stating that it is unfair to shift the burden of juries to figure out what's literal versus figurative, and also the risk of bias. And so they have asked for this. So this is being seen at a federal level. It also mirrors legislation that successfully passed in Louisiana and in California. And it also mirrors the bills that were mentioned before that have bipartisan support currently in Missouri and Maryland.
And so in the federal system, is this some sort of judge-made common law that's developing, or are you referring to them just because there was a quest for some clarification?
So it's a combination of things. So this will, at a federal level, it would be an amendment, just like it would be here, Georgia, to the federal rules of evidence to create clarity. So this isn't something that was started at the behest of judges. However, due to, as Representative Bell brought up, due to the prosecutorial environment here in Georgia, there have been an upspring and an increase in cases where prosecutors are able to use creative expressions without much guidance for courts or instructions for juries about how this evidence can be used. And so it's a chain effect, I would say.
Okay. But is there any like federal jurisprudence where their courts have been applying these rules or something like this, and you're trying to clarify it, or has there just been a call at the federal level for some kind of legislation to set standards?
This is a good question. So in the actual federal case that I mentioned in the Eastern District of New York, that was last month, and even here locally in the case that is in Fulton County, both judges applied the standard here without it actually being a part of law, but stating that this was their particular interpretation of requiring a foundation of admitting the proof and not automatically including it because of constitutional issues like freedom of speech, freedom of expression, and the right to a fair trial, and the risk to jury bias that people might have to, let's just say, country music and death ballads or hip hop music and rappers. And so because there is this risk of bias, those judges have determined in alignment with this language in the legislation that there should be these types of guidelines for the admissibility of this type of evidence.
So it's sort of a prejudice. The probative value of the evidence is outweighed by the prejudice it might cause.
Correct.
Yeah, okay. All right. I know I think I've been hogging the microphone, late Chairman, if you.
Thank you, Mr. Chairman. Good questions though. So I guess I'm just trying to think of examples where it would be admissible. For example, if there was a pattern of activity in a criminal case, for example, and I mean, I'm assuming again, if it meets this test, this 4-point test, that a pattern of activity would be admissible. And then the other instance would be particularly establish someone's mens rea in a criminal case, their mental state at the time of the crime. To me, this would be tricky, very, very tricky.
So thank you for your questions, and they're very interesting. So I'll take them in two parts. So the very first question, yes, you're absolutely correct. And I think it's really important to emphasize that this is not a get out of jail free card, and it actually creates a clear standard for prosecutors and judges to get in relevant evidence. If you use your creative work, if you are Stephen King and you are literally out here killing people and being a serial killer, and you decided to write a book about it, absolutely, you deserve to go to jail. If you wrote a song about a murder and you actually committed the crime, and I have actual facts that tie you with this crime, along with lyrics that tie you to a specific crime, absolutely. However, that's not the current state of affairs. There are individuals such as Mac Phipps, an individual who is in the state of Louisiana that led to the passage of similar legislation here, who served 21 years for a crime he did not commit. He was a poet who based songs on his father's military experience, but put it in the context of the street neighborhood that he grew up in. The DA, who was later found on corruption and fraud charges, ignored the testimony of witnesses, intimidated some witnesses, and put him in jail using the lyrics of this album and a rap persona that was not his actual real life. And so that's what we're trying to avoid here. So for your second question, when you talk about the mens rea and the slippery slope of using those things, that's exactly what the 4 points go to. We don't want to say, oh, I put a bullet to his head, you know, just to watch a man die, or the Johnny Cash lyrics, right? We don't know if that was his mentality and he wrote that song and he said, I intended to kill someone. We need there to be both the lyric of the song and him actually committing the crime and the timing of when the lyrics was written, to say this was written. We can prove that this was written in a studio session 2 hours before you went out and actually shot a sheriff. And so that is all that we're asking for. We are not asking for a clear slate here for criminals to get away with and write songs about their crimes or make shows about their crimes, but we are asking for that level of standard for the admission of the evidence.
Thank you. Thank you very much.
Thank you. The chair would also just note the actual lyric is, I shot a man in Reno. Just watching.
3 different songs.
Representative Crowe.
Thank you, Mr. Chairman. Sit where a mic works, but this is probably better. So I was asking my learned colleague over here, and I just want to make sure that I understand this procedurally from this bill. And I think you may have touched on it. There's some ongoing cases now in Atlanta, obviously, that a lot of people are familiar with. And I think Representative Bell and I talked about this when he came and spoke to me about this bill. And it's better now than when I think it's come a long way since we first talked about it. My only concern is I want to make sure this isn't going to have, if this goes into law before that trial is complete, because they could take quite a while, it's not going to have any impact on current cases ongoing, correct?
No, it will not.
Okay. All right. And I think you touched on some of that, but did you say, I was talking and didn't hear completely, that the judge applied some of these tests in that case on his own?
Yes.
Okay. All right. Thank you.
In the Georgia case?
Correct.
Okay. Any other questions? I don't see any question. Oh, wait, Representative Neal.
I'll make a move at the appropriate time.
All right, I think we may have another witness or two. So that appropriate time will arrive. but-
Should I?
I'm sorry?
I'm actually on the sheet. Should I just give my statement?
Yeah, if you've got some additional testimony, yes, let's go ahead and do that while you're here.
Thank you.
I assume that's what you had been doing, but if you've got some other comments, yes, please.
Again, thank you, Chairman, and to the committee for hearing this board. Of course, I'm here in support of 990 to protect both freedom of speech and right to a fair trial in the state of Georgia by creating appropriate prosecutorial limits on the use of creative expression in trial settings. The Innocent Project has done a study that has estimated that 1 out of every 10 criminal cases actually results in a wrongful conviction. So if we put that in the context of the state of Georgia, there's about 95,000 people in our local and state prison systems. That means that there's potentially 10,000 innocent people behind bars, but also 10,000 criminals that are still on our streets that have not been properly charged. And 2 of the reasons that there were wrongful convictions were actually the introduction of irrelevant evidence and bogus expert testimony. And so here, HB 990 seeks to eliminate the use of irrelevant evidence and testimony regarding the interpretation of these lyrics by creating a reasonable guardrail for the introduction of creative expression. The literal livelihood of my clients, who are parents, some single parents, caretakers, and leaders in their communities, are at risk of being stifled when prosecutors are allowed to use figures of speech to establish evidence of a crime instead of focusing on actual criminals and utilizing actual hard evidence of crimes when crime is a real problem in our state. Today, it is currently rap, but tomorrow it may be country. And Miranda Lambert is charged with aggravated assault with a deadly weapon for her story of domestic violence in her song Gunpowder and Lead. Or Jason Bateman, the lead actor of Ozark, filmed here in Georgia, being charged with money laundering for utilizing lines from episodes in the show in the indictment, the same way rap lyrics from an album were used to indict artists. I want to be clear that HB 990 is not a get out of jail free card, but is carefully crafted to be specific and acknowledge the role of DAs in society for public safety while preventing purely imaginative creative works by imposing a 4-part test for the admissible evidence and prevention of jury bias. This is a deeply common sense law that other states have moved on, as we've mentioned, in Missouri and Maryland, and successfully passed in California and Louisiana. We as Georgia have an opportunity here to take the lead in what is a deeply common sense bipartisan issue, as illustrated by the support of Chairman Casey Carpenter of the Creative Arts and Entertainment Committee being a co-sponsor in this bill. We are not by any mark saying that judges are always wrong or prosecutors are always wrong, but we are saying that there needs to be a standard rule for courts to give the best chance at getting it right, as opposed to leaving it for jury conjecture. The right to a fair trial impacts Georgians in urban and rural areas, families on both sides of the aisle. And so support of 990 sends a clear message to Georgians that they can trust our judicial system to be one that is focused on solving crimes with integrity, and that our legislature treasures the right to free speech and creative expression. Thank you.
Thank you very much for your testimony. Do we have any other questions of the witness? I don't see any lights, so thank you very much. Let's see, we had, is it Rustin Marsh?
Reagan Marsh.
Reagan Marsh. Sorry, Reagan, I couldn't read your handwriting.
Mr. Chairman, members of the committee, thank you for the opportunity to speak today. My name is Reagan Marsh with Troutman Pepper. I'm here on behalf of the Recording Industry Association of America. I've submitted a letter to your folders that you should have, and it is simply RIAA expressing support for this bill. They're a trade group that represents members that create, manufacture, and distribute sound recordings, and we're here today on behalf of our members. Thank you.
Thank you. Any questions for this witness? I don't hear Reagan. Thank you very much. I'm sorry I got your name wrong. Is there anyone else that wishes to testify? Robert, do you wish to give us PAC's perspective on this?
Some people still call it the old code and the new evidence code. When we adopted the most recent, Robert Smith, Prosecuting Attorney's Counsel. For the non-lawyers, the evidence rules are the rules that we have to govern whenever we want to introduce evidence. A couple of years ago, Georgia had a very antiquated or outdated evidence code, and this body decided to modernize it. And the intent was to adopt the federal rules. This bill, one of the questions and one of the things I want to point out is that it goes into, as you know, the code is broken up into titles and chapters. This goes into Title 24, which is the evidence code, the Chapter 9, which is about 923. 9 is about specific types. 9 is about authentication and identification, and 923 is about the admissibility when witnesses are unavailability. When witnesses are unavailable. It's not about admissibility, about evidence generally. It's going in, basically it's going into the wrong code section. That's what I'd suggest to you. It needs to go into, as the previous speaker was talking about, the balancing test. Evidence generally is in 24.4. In fact, that's where the federal law, and that's the thing, the bigger point that I want to make to you. If you want to do this, follow your intent that was stated several years ago, which was to adopt the federal rules. Adopt the federal law that's being debated in Congress. This is not what the federal law looks like. It looks like something different. There's references to civil as well as criminal. If you want, what I'm looking at on my reference is adopt whatever is available under the RAP Act of 2023, the Restoring Artist Protection Act of 2023. Use that keep us current, keep us in line. Because if we don't, that means we won't have anything to bear off of. It means that if, when we have a question, we can't look to federal court decisions about the admissibility of evidence. That's what I'm asking you to do. Keep us concurrent, keep us consistent.
So it sounds like the concern is the prejudicial value of that evidence in a criminal case, right?
It also would probably have, I would have posited it would have it in civil cases too, but we're not, we seem to be talking about criminal only.
Well, and I wouldn't object to, as Roy Barnes, you say, eating that off at one spoonful at a time. I mean, we could do part of that now, but there already, and I don't do a lot of trial work, so I'm not as versed in the evidence code. But there is a provision already on prejudicial. I mean, that is a basis for exclusion of evidence if the prejudice or confusion or misleading outweighs the probative value.
Yes.
Right. Okay.
And what this, and how this steps up is this basically, this bill is drafted says it's inadmissible. I mean, basically it starts off being inadmissible.
There's presumption of inadmissibility unless you can overcome it.
And the language, and I recognize we've got the recording artists in the room, the recording industry in the room, but this isn't limited to just rap lyrics. This isn't just limited to, apologies. This isn't just to music lyrics. When it talks about creative and artistic expression, it's a very broad group of things: sounds, words, movements, symbols. Anything that's, any expression or application of creativity or imagination. I'll let your imagination fill in that blank as to how far this could go. And the default is inadmissible unless we meet the 4 factors. So we've just, not too long ago, less than 24 hours, this committee was debating about, and maybe in a few minutes, talking about computer generated child pornography.
Let me ask another question. Customarily, if there is an issue about admissibility that is decided in sort of a, not in camera, but outside the presence of the jury, what is there a common standard that you would have to overcome? If you've got to prove certain things to get it in a criminal case, is that standard usually beyond a reasonable doubt, or is it preponderance, or does it differ?
It differs, but the evidence rules set up as rules of inclusion, not exclusion. That's the other thing too that's unusual about this rule. The rules that you drafted and gave to us say the rules were meant for the inclusion of evidence, not the exclusion of evidence. So this is a rule that's kind of already going in a different direction by saying keep it out, but only let it in under these circumstances. Usually it's let it in and let the jury, and then guide the jury as to what it does, and keep it out only if there's prejudicial effect, only if there's a violation of privilege. That the rules say themselves, these are rules of inclusion.
Mm-hmm. Well, and I would think the sponsor would probably say, well, there's a constitutional issue at stake here that would justify that, but no, I may call on y'all, come back. Floyd Hall.
Thank you, Chairman. And so I think that's where I was kind of going with in the beginning, and what confused me. We're already stating with it's inadmissible, versus in what we do now is if we believe that evidence should be thrown out, we file motions and prove that it should not. But here we're basically, it's the opposite is what we're doing. Saying this shouldn't be in the beginning because it is creative or artistic expression, and now prove that it's not. And so I'm a little concerned about that part. And am I correct in what you're saying? Is that what you're stating and what this bill is doing?
Yes, ma'am. And then the other factor is our Supreme Court has said that even if we pass this test, even if we, show the 4 factors and get in, if this were to become the law and we had a piece of evidence, it was, excluded, but then in a case, a lawyer is able to get it admitted, it still has to survive 403 balancing. We still, evidence can still be kept out if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue time, waste of time, delay, or needless presentation of cumulative evidence. So it still still can be kept out even after we've overcome this test.
And so that goes to my second question, if I may, Chairman. Do we already have something that is that will allow this to be excluded, what we're trying to do here? Or do you think we don't have the term creative or artistic expression defined enough for our judges or jury to be able to decide that?
Yes.
In your opinion?
Yes, to your, yes, it's not, those terms are not in here. Those terms are not defined. And the case down the street is going to be probably what defines it because of the extent that it's being used, the extent that it's being litigated. And if there is ever an appeal off of that case, I have no doubt that it's going to, the evidence code is going to be altered because of what was allowed or disallowed.
And if I may, I'm sorry, one more question with that then, and this could be, I don't know if you can answer it. I haven't really followed that case. Do you know, did that case define what that creative or artistic expression is? I know there was arguments back and forth, but did that case?
I don't know because I'm not involved in the day-to-day details of it. My office is not involved in it. And, I wish I could have brought somebody if they were available to testify and talk about what's going on down there. I'm not saying also that, First Amendment gets checked at the door because you're suspected of committing a crime at all. No, it's just, if you're going to change the rules of evidence for every criminal case in the state of Georgia, let's just try to be consistent and understand how everything else works together.
Thank you. And Representative Bell, if you have an answer to the last question, I would appreciate it.
First, to his point, irrelevant evidence is already inadmissible in court. And this, we're more than happy to move into chapter 4, as well as this, the man possibly doesn't know what he speak of, but this is identical to federal language and concept. As far as we're speaking about this bill, this is identical to federal language, as well as already has support federally by the SAG and the Actors Association. So it's not just the recording industry, it's the film and broader entertainment industry that supports this as well.
All right, Robert, did you?
If House Resolution 2952 is different than what I'm reading off of the website, the U.S. Congress's website, I apologize. But I'm just, I've Googled the act and I'm reading it. And as I look at it, it is not the same as what's contained in House Bill 990.
Okay. All right, I've got a few other questions. Representative Neal?
Yes, I have, the sub I have is LC 481252S.
Yes, thank you to the chair. So question, what would be your recommended fix to adjust the bill to be more appropriate for this matter?
I would be consistent with the federal government and what U.S. Congress is going to be pushing forth, because that's what you said originally to us when you adopted the evidence code, was you were adopting the federal rules of evidence. So if there's going to be a federal change, adopt the federal change.
But you said it's still being debated. Is that correct? Is this HR 2952, the RAP Act you're referencing?
Yes, ma'am.
Now, I think Chairman Smith is still mad about that decision, by the way, but
that's here's the thing. You adopt this and you adopt 990 as it's currently written. And then then Congress passes the RAP Act, which I contend says something different. The sponsor says it's the same. If there is any difference, then that means Georgia now has a different evidentiary rule than the federal government does. And that's my only thing is if you want, there's nothing wrong with Georgia being a leader. I mean, we've talked about this in this committee, the full committee, as well as the subcommittee, about Georgia has been a leader in certain things. Be a leader, but just understand that you've told us you wanted to be the same as the feds earlier. And that's what I'm.
So I guess my question is it appropriate for us to model our legislation off of federal legislation that has not been completely
adopted yet?
Adopted. Like we can establish our own until such time. Is that not correct, or help me? Because it could fail and we modeled our our legislation off of something that hasn't went through the full legislative process.
Yes, yes, you could. And you know, that's,
And I know a lot of people complain about what the feds do. So do we have to wait on them to do our work?
you don't have to, but understand that if they pass something that's different, you know, it's basically, you pick one. Which one do you want?
But I think the point is, in our evidence code, we have generally tended to gravitate toward federal rules. That was the decision that was made some years ago. That was a rather controversial decision when it was made amongst the bar anyway, but that's what we did. But we're certainly free to adopt whatever we think is appropriate. If there's some minor variations from it, that's our decision, I think. So do we have another question of Mr. Smith? I don't think we do. All right, thank you so much.
Thank you.
Ms. Lawson, would you like to respond to some of that? And it's fine if the answer is no, I do not wish to, but I just didn't know if you seem to want to, so.
Thank you, Chairman.
For a few items of clarification, this does model HB 2952. Sections 1 through 4 that I read aloud to the committee identically mirror sections 1 through 4 of the proposed federal bill. I'm sorry. No, I'm sorry. So yes, lines 30 through 35, yes, Chairman, capital A, capital B, capital C, capital D mirror the sections in the federal legislation of 1, 2, 3, and 4 of the federal bill. So just to clarify that. And the second point of the gentleman as it related to creative expression encompassing more than music, and that is absolutely correct. And that is why we are here stating that we need a protection for creative expression. And the mirror example that we provided before is the nuances and the particularity of the medical profession, and not asking jurors to look at a doctor's medical notes and parse through what the diagnoses and the codes are. Artists have their own vision and their own words about what they mean in movies and in televisions and songs. And without this piece of legislation, we are asking juries to parse through what authors and actors and songwriters meant without having proper foundation. And that really is the crux of what the bill here is, to address Representative Hong, your issues with admissibility. The Georgia Code actually does provide standards that require evidence to be relevant. And as I mentioned earlier with the Innocence Project, that irrelevant evidence and bogus expert testimony are the reasons so many criminals are still on the street and so many innocent people are in jail. And this seeks to guide courts and prosecutors to ensure that the evidence is relevant and allows it in properly. Thank you.
Thank you. You're awesome. All right. Is there anyone else who wanted to testify as to House Bill 990? All right. I've got a Representative Gullett.
Yeah, I move we table.
I have a motion to table. Do I have a second?
Second.
I have a second. All right. I don't know if a motion to table is debatable. Is there any discussion? All right. All those in favor signify by, we do. Representative Neal.
Yes, thank you to the chair and to the body. I think we are in a position where we can kind of, make our own decisions, here and not have to wait on any, federal decisions, like has been testified to us. I would recommend us reconsider tabling if we could.
Well, I think a motion to table, I think has
Precedence.
precedence or priority or something. And so I think we've got a motion a second. So I'm going to go ahead and call the question. All those in favor signify by saying aye.
Aye.
All those opposed? All right, I think the ayes have it. All right. Thank you, Representative.
Thank you all.
And thank all the witnesses for their testimony on this too. All right, Representative Lupton, I think you're, after having been very patient over there.
Are both of these on or is?
They are both on, but you pick whichever one y'all would like.
I'm gonna be
Oh,
here.
We've
and
got double team.
My expert's gonna be here.
All right, go ahead and tell us about your bill. This is House Bill 1367.
Thank you so much, Mr. Chair. I am working off LC 570093. There is no substitute for this bill. And I mean, if it's not broke, don't fix it, right? Boy, just stretch a little bit. God, we've been sitting for so long. Right, yeah. Some people, if they're lucky enough. What this bill seeks to do is to expand the definition of forensic medical exam to include evidence of strangulation. What does that mean? Right now, a forensic medical exam, or an FME, is what occurs after someone has been sexually assaulted. A specially trained nurse called a SANE nurse, a sexual assault nurse examiner, who is a RN who has gone through extra training to collect evidence of sexual assault, will perform an FME. They will collect evidence, which is, holds up in court, the rape kits that we all hear about. This is where that gets collected. These nurses, these SANE nurses, are compensated under the Georgia Crime Victims Emergency Fund for each exam that they make. Now, that's what's currently in code. What some SANE nurses have done is they've gone another step and gotten specialties in strangulation exams. Why are strangulation exams important? Strangulation exams are important because when a perpetrator attempts to strangle or strangles a victim, it's a really good indicator of how dangerous they are and how risky they are to the public. They're much more likely to kill. And the people who are associated with them and attacked by them are much more likely to die in the future. So strangulation exams collect evidence that has stood up in court and can be used to help sentence appropriately. But the women who have gone, or women and men who have gone through this extra training, are not yet compensated for those strangulation exams because the definition of a strangulation exam is not included under forensic medical exam. So what we seek to do is just tie that up a little bit and have these nurses who are doing very important work compensated for their extra training and time when it's appropriate to do a strangulation exam.
Are we adding to this definition so that a victim can get compensated, or so that the person performing the examination can be?
It's the person performing the
Okay,
examination.
okay.
These forensic medical exams are of no cost to the victim. And as I said, they are the nurses that do these exams are compensated under the Victims Emergency Fund, under the Crime Victims Emergency Fund.
Okay, thank you. Floor Leader Hall.
Thank you, Chairman. Just because I don't know, what's the difference between the examination for strangulation versus what we already have, physical trauma? Is there so much more that goes into it that is costly?
Right. I'm gonna introduce Heather Williams right now. She is a trained SANE nurse with a specialty in strangulation examinations. She and her coworkers are the ones who told me about this type of exam. I didn't even know it existed. Is it all right? I'm gonna pass it on to her to answer that.
That'll be fine.
Can I use this one?
Yes, ma'am. That should be on. You just
Right.
tell us your name and.
Certainly. Good afternoon. My name is Heather Williams. I am a forensic nurse. I am a certified SANE sexual assault nurse examiner in adult and adolescent cases. And I work out of the Refuge in Vidalia, Georgia, which covers 7 counties. The difference is a victim does not have to go to the hospital And a lot of times they don't go to the hospital. This and a lot of our services are provided in centers that are not in a hospital setting. Mine is a community. We are not in the hospital setting. So oftentimes if they choose not to get medical care, but law enforcement can talk to them at the scene and encourage them to get to a center, which is a little bit less invasive, and get that exam by the sexual assault nurse examiner or the forensic nurse, we are trained to identify certain areas of injury that are already presenting, but then also to talk to the victim about injuries that may not have been presenting yet. For example, one of the biggest things we're concerned about after a strangulation is a carotid artery dissection. What that means, layman's terms, we've got big fat vessels in our neck, both sides. Carotid arteries bring oxygenated blood to our brain. If they dissect or tear, we can get damage that can create a clot over time, and it could be years after that clot can break off and can travel to the brain, and we have a stroke victim. However, without actually talking to someone who is trained in this, the victim doesn't understand that and doesn't get the opportunity to have that conversation where the nurse is going to say to that victim, it's my recommendation that you go to the emergency room and be evaluated at a higher level of care, and you can get diagnostic studies that are performed to specifically look at those vessels and catch those tears early and identify them instead of waiting 6 months, 12 months, or longer to have that patient actually suffer a stroke. So we're trained head to toe, identify injuries, have that conversation, take photos, and give that over to law enforcement and let them do their job from there to provide more evidence for the case.
Thank you. Any questions? Is it Representative Crowe?
Yes, sir. Thank you. So is this your examination for strangulation is done separately from other forensic examinations? So when the victim is examined via a forensic medical examination, you're only going to do the strangulation portion of it, or are you going to do all of it and include the strangulation portion? Or are you called in? I guess a better way to ask it, are you called in as an expert just for the strangulation portion, or are you doing the entire medical examination?
We are called in when there has been an assault. If it's been a sexual assault, my nurses are on call 24 hours a day. I'm full-time days, and I have contracted nurses who come in nights and weekends. If it's a sexual assault, that nurse can come in and perform the head-to-toe sexual assault exam, the rape kit, and then we submit for payment from victims' compensation, and therefore I can pay my nurse. The problem with these exams, and the only reason why law enforcement and medical professionals know that we do this, and there are only currently 2 programs in the state that offer non-fatal strangulation forensic exams alone, just that exam. At the core though, I'm a nurse. And so when I do a non-fatal strangulation exam, it is a head to toe. It's looking from top to bottom, identifying all injuries, potential or actual. So it's not just looking at the neck, it is a full head to toe exam. So, and if there's anything that requires more care, we send them to the ER or recommend they go to the ER if they want to go.
Okay. And I guess that is the question. If you're not, because I want to make sure that you're compensated.
And at this time, if there's a strangulation that comes in during my shift while I am on the clock, I do it. Law enforcement calls me, I meet them at the center, we do it. If it's after hours or on the weekend, they will not get seen by a forensic nurse until I come on Monday. Or if I'm out of town on vacation at my center personally, they won't get seen by a forensic nurse until I am available, because I cannot pay my nurses to perform that exam because I can't be reimbursed by the state for the exam.
And that's only the strangulation exam, not the entire forensic medical exam.
Well, and it's all the same thing. It's all the same thing. The forensic medical exam is the strangulation exam. It's called strangulation because that is the mechanism of injury, but it's a whole forensic exam head to toe.
And I guess I'm just trying to figure out why we're adding this, paragraph C here, because it sounds like it is all inclusive, right? I mean, and I will be fully honest,
Right.
I'm not familiar with that. I was an investigator for a good amount of time with the police department, and I've never heard of a strangulation examination, so it's new to me. But it sounds like it's all one exam that it's being done, so I don't know what the reason is for adding this language here. I want y'all to be compensated, and I appreciate what y'all do. It's valuable and very needed. And I want to make sure that you're compensated for, because I know it takes a lot of time and training to get those specialties, but I'm trying to figure out why we need to add this language if it's all the one exam, if that makes sense. And I may not be asking it properly, but that's all I got.
No, that's it. That's okay. I brought this forward because I went to a sexual assault center and asked, what can I do legislatively? And it's specifically the strangulation, the people who have extra strangulation training that can do that full exam. So if you take a regular an FME, and then you've got this extra little bit of skill, which only 2 programs in the state have right now, they're compensated for this, but not for this. And only the people who do this could be compensated for it. But the people who do this part are still not compensated for that part. Does that make any sense? Yeah. I hope I said that right. Is that okay.
It's a bigger problem across the state than we realize. We just don't see it because centers and programs aren't available to do the cases. Even if they have nurses who are specially trained, they don't have the compensation. They don't have, the law enforcement isn't aware to bring them to us. So it takes a lot of groundwork, a lot of training, a lot of teaching medical professional and our law enforcement partners that it's something that we can offer. But most programs, because of the lack of payment, can't even offer it. Now, if there's a strangulation that's incorporated in a sexual assault, that's taken care of because it's a sexual assault. It's part of the head to toe. What this is covering or asking for compensation for is strictly those cases that include a strangulation component only, not the ones that have a sexual assault with it. Because if it's a sexual assault with a strangulation, it's paid for. The sexual assault part, it's taken care of. This is just for those with the strangulations. The fatality rate is crazy. We know that after the first time that a victim is strangled by their abuser, their likelihood of being killed by that person increases by 750%. We know that the majority of our offenders who kill our police officers, if you look in their backgrounds, the majority of them have domestic violence and strangulation histories. So this is personal for our police officers to get them off of the street. It's personal for the families and for the victims and anybody else that they meet down the road. And they don't get better. They don't get nicer. So it's our job, it's our work, and the fatality and the rate of possible stroke, they don't know that until they get in front of a trained nurse to be able to hear that information. So we just want to get them to us to be able to do that exam and talk to them and encourage them to get that diagnostic care. But if the nurses aren't being able to be paid, they can't do the exam. If they don't do the exam, they're not told about the risk of the stroke and possible other medical consequences.
Make sure I understand. The statute we're amending is within the Georgia Crime Victims Compensation.
Yes.
Article or title. And so is it, I was just looking through here. I didn't see where it authorizes the board or the fund to pay directly to a provider. Is the issue that the victim can get reimbursed for the cost so that you can then get paid?
The victim is not paid. Everything
Victim
is
doesn't
covered
pay
free
anything.
for the victim. They are never charged and they never pay anything. The victim comes into the center, they have their exam. There is a fee schedule currently for sexual assaults. And we bill according to that fee schedule. We bill to victims' compensation as the refuge. We send the bill in and they send us payment. And then from there, I can turn around and pay my SANE for doing that exam.
Okay.
A
So
flat
you-
rate fee for
so
the
you're
exam.
able to make a claim on the fund for the.
Yes.
Yes, sir.
examination. Okay.
Yes.
I just.
And
get-
currently there is none for a strangulation exam.
I understand. You're saying if it was part of a larger exam that is already authorized, you can get it, but you can't get it if it's just for the strangulation.
Yes, sir. That is correct.
I couldn't find it in the statute, but I'm trying to look through the computer, which I never enjoyed
Right.
doing anyway.
And I asked CJCC, give me a ballpark on the fiscal impact of this. They have not gotten back to me yet. They were like, hey, we'll get back to you. And I've been texting with them all day and they, it's a busy time of year. But that's what we're looking to do. So I wish I had more information as far as that was concerned, but it's forthcoming.
Okay. 17 is Representative
Yeah,
Gully.
but do you know how many exams would be done per year? I know there's only 2 places, but how many exams? Obviously, not many exams are done. How many should be done?
It varies so widely. I can only give you my personal experience. I personally have done 80 non-fatal strangulation exams. We just started doing them in 2019, and I am in a very small rural area. I know that Fulton County and DeKalb County must get a lot because I am consulted often as a strangulation expert to come and testify.
So you got an 80 in 5 years, 4 years, whatever.
Yes,
4.5
sir.
years. Okay.
Yes, sir. And that's just the individual strangulation. That does not include strangulations that happen with a sexual assault. So there are many, many more. That's just the ones that are just the strangulation and just the ones that get to me.
Are most done through sexual assault versus independently without a sexual assault? Just in your experience?
It varies. We see them in domestic violence and we see them in sexual assaults. So there's really no differentiation. It knows no boundaries.
Okay. Thanks.
Questions of the witness? All right. Thank you. We've got a few other witnesses here who want to testify. Is it Karima? Am I doing that right? Okay. Ms. Diller, if you want to come up, we'll get to hear from you on this, on 1367.
Do you need me to? Oh,
You,
I was
you
going to
just-
play musical chairs with you, but if I don't need to, I'll just stay here.
No, you can just stay right
I'll park myself here like a queen.
there.
Well, good evening, Chairman and members of the subcommittee. It is evening just about now. My name is Karima Dillard, and I am representing the Georgia Coalition Against Domestic Violence. I'm also here today representing the Georgia Network to End Sexual Assault. Our 2 programs are member-based programs consisting of domestic violence and sexual assault centers from across the state. And we are here in support of this wonderful piece of legislation. I want to just kind of make the point that we're talking about strangulation that was made a felony offense in 2014, but most people really don't understand the lethality of strangulation. Strangulation is an accompanying offense with domestic violence, with sexual assault. And most people who are victims of strangulation often don't know that they're victims of strangulation. They don't believe they need to seek medical attention. They don't understand the dynamics and they don't understand how fatal it can be. So we're talking about less than 10% of people who are currently victims of domestic violence who actually seek medical attention for strangulation. And I want to say it's about 50% of folks who experience domestic violence are also victims of strangulation. So that's a pretty huge gap. And we want to make sure that people who are trained, medical personnel trained to understand the signs and symptoms of strangulation and how to treat it are compensated. So we just want to go on the record saying that we absolutely support this bill and happy to answer any questions that you have.
Thank you. Thank you for being here. Any questions for Ms. Dillard? I don't see any questions. Thank you so much, Ms. Dillard. Let's see. Oh, Ms. Jackson, you wish to speak to this bill?
Yes, thank you. I'm Charlotte Jackson with the Prosecuting Attorneys Council, the Domestic Violence and Sexual Assault Resource Prosecutor. When we first changed the law on strangulation, the reason that we had to do it is because we knew it was serious, but there kind of has been a nationwide knowledge gap on the lethality around strangulation, also the commonality. Strangulation is one of the best tools that batterers have in their toolbox because it doesn't leave visible injuries.
And so what the research has shown over the years is that with proper medical exams, we can identify crucial evidence that corroborates our victim stories, that proves that a strangulation happened, and it allows us to hold those batterers accountable, making families safer, getting those offenders off of the street, and protecting our police officers. And so making these exams accessible to victims all over the state of Georgia will make our state safer by providing that needed funding that we as prosecutors need to have the evidence that we need to do our jobs as prosecutors. And so that's why I, as a prosecutor, support this bill.
Thank you. Any questions for Ms. Jackson? I don't see any questions. Thank you. Did anyone else wish to speak to House Bill 1367? All right, I don't see any. I know. It's nobody wishes to speak. Apparently nobody really cares about voting for it either.
Trust me, I know.
All right, so I think we've heard all the evidence. What's the pleasure of the committee? I have a motion to pass. Do I have a second? I have a motion and a second. Any discussion? All those in favor signify by saying aye. All those opposed, like sign. All right, it passes. Congratulations.
Thank you so much.
Is this your first judiciary?
This is my first judiciary. I mean, if I'd known, I would have packed a bag. I mean, geez.
Yeah,
Now I know better. Don't go for,
I was gonna say,
no, yeah.
hang around for the hazing ritual. We gotta get to that.
Thank you so much. I'm already hungry.
What?
I said I'm already hungry.
Don't leave it all. Okay.